about David Aguilera's failure to conduct an investigation during the period of August to November of 1992. I have not spoken to Special Agent Aguilera about that, and I understand he may be a witness later on. But based on my experience, I'll tell you what the answer is. During this period of time, Mr. Aguilera works for an agency that's assigned to Treasury Department. Those of us who are in law enforcement know that Treasury Department, from about midsummer until November, is tied up in the campaigns. That's their main function. They borrow from Customs, they borrow from ATF, they borrow from Internal Revenue Service. They get as many special agents as they can to augment their Secret Service. I would be willing to surmise, and that's what it is at this point, but I would be willing to surmise that Mr. Aguilera will answer that's the reason that he could not conduct any investigation at the time. It is not, though, or the risk is, the danger is that it's a basis on which someone has formed an opinion, and then based upon that opinion, they start to scour the record looking for evidence that will support that opinion. And that's what I hope and I feel this panel will steer away from in this particular regard. For instance, the other gentleman made some comment about how this was an ordinary religious movement out there at Mount Carmel. I beg to differ with you. My hair stood on end when I read the interviews of 5- and 6-year-old children that came out of Mount Carmel knowing how to commit suicide, knowing to put a gun barrel in their mouth and blow the top of their heads off. That is not ordinary religious doctrine. That is not what we were dealing with. So that's one of the reasons I wanted to try to share with you some of our opinions that we came to over this period of time. And the first opinion, we prepared a joint statement which I'd like to ask to be submitted and made part of the record. But our first opinion was basically that the Branch Davidians were not coming out. That was a decision that was based, or an opinion that came to be held by virtually everyone as of the middle part of April of 1993. The tragedy that's involved here actually begins back in 1992 when David Koresh makes his prediction, moving his timetable initially from 95 up to Passover 93. In the Passover season of 1992, this is based on our witnesses' testimonies, he predicted that that was going to be the last Passover, that sometime during the year of 1992 to 1993, the confrontation with the beast, which in this regard he personified as the government of the United States, had to occur. That was his theology. It was based on his theology. The followers were there. They believed in David Koresh. They believed his teachings, as every survivor who testified to, that Koresh meant death. They followed that particular belief. They were there to die. They were there to die, and according to Koresh, they were either going to die by bullet, they were going to die by fire, they were going to die by tank, or if they were fortunate, they would be translated to heaven without having to go through the agony of death. But the one message that he taught, and this again was testified to by the 3 survivors who testified on behalf of the United States, was in order to show your worthiness to go to heaven, you had to be willing to kill. You could not die for God if you could not kill for God. And in the words of one of the survivors, there were no conscientious objectors at Mount Carmel. We were prepared to prove, but the court excluded it for the reasons I'll tell you in a second, of an instruction and a plan that David Koresh discussed with his followers. And this was what we call the McDonald's plan. And in that, he encouraged them to go out in the community in order to force a confrontation with law enforcement, to go out in the community, take over a public facility, a McDonald's, or if you recall, there was an incident in Killeen involving a Luby's cafeteria. Take over a facility, take the people inside hostage, hold them at gunpoint, and force them to admit that David Koresh was the Lamb of God. If they refused, he encouraged and directed his followers to do so, to kill them if they refused. It was our opinion that what he was trying to do here was to force a confrontation with law enforcement authorities. He later backed off on that. He later came back and said, well, it was just a test. And of course, if any of you are familiar with Jonestown and the actions of Jim Jones, that's what he did to condition his followers to take the poison cyanide, was to go through these tests of it's time to commit suicide, it's time to impose these things, drink the suicide and die. He also, during the same period of time, and you'll hear from this witness, he testified to it, or told an outsider who was there examining the child abuse allegations. He told her that when I reveal myself, my true identity, the riots in Los Angeles will pale by comparison. This is right after they had the major riots in Los Angeles. We were also prepared to prove through the testimony of witnesses that even when that lady came to make her interviews, the Branch Davidians had intentionally kept away from her the small children who were David's children. They did not want to see the 15 or 16 children that ran around at about the same age that were David's children, because they were afraid that if they did, they would start questioning the ages of their mothers. Indeed, one of the plans that we had in the event that we've been successful in obtaining David Koresh's arrest was to take DNA samples from him and from his children to prove that he had been having sex with minor children, and then to submit that to the state so the state could prosecute him for being a child molester. We established that David Koresh intended to have a confrontation. That's what he was after. He was going to have a confrontation sometime between Passover of 1992 and Passover of 1993, and unfortunately, it was ATF who stumbled into that intent. Unfortunately, it was ATF who arrived on February 28th to initiate or execute a lawful search warrant, and instead, Koresh had 45 minutes warning, had a notice that they were coming, and spent that 45 minutes, instead of preparing to surrender or to arrange his resident counsel, he had a lawyer inside the building with him, to arrange a surrender, he spent that time preparing to resist the agents. There's some surmise concerning helicopters and whether or not the helicopters shot at the Davidian compound that day. We presented the testimony of Mr. Maloney. I know Mr. Rivas wasn't there during the course of the testimony, and he had to go back and read Mr. Maloney's testimony. Mr. Maloney was quite clear using a map that what he was talking about was not the first intersection, but he was talking about being in a location some mile behind the compound, back behind the hills. This is a very hilly area. And then beyond that, seeing the helicopter circling. And that was perfectly consistent with the testimony of the citizen soldiers of the Texas National Guard who were flying those helicopters that day, that they did, some distance away, some miles away, orbit, because they were trying to wait for the time factor. They did not realize that the rate had been moved up. There was no testimony from any pilot or any person on board those helicopters of any gunfire, but more significantly, there were videotapes that were made from those helicopters, and they were delivered to defense counsel, and they were played for the purpose of the jury. There is no evidence, no sound of any gunfire coming from any of those helicopters. Indeed, you can hear the bullets striking the helicopters, but you can't hear any sound of any gunfire going out of those helicopters. With this kind of mindset was also confirmed the fact that there was a suicide pact within Mount Carmel. This was something that wasn't discussed that much in the press, but every survivor testified concerning that suicide pact. And basically what the design was, or what the plan was that David Koresh thought he was dying. He thought that wound that he received on February 28th was so severe that he was going to die, and when he died, his followers were going to come with him. When he died, they were going to put his body on a stretcher. They were going to come outside with their women and their children. The mighty men, the men that were loyal to him, were going to be carrying his children. They were going to have guns and hand grenades concealed. They were going to pull those guns and hand grenades and open fire on the FBI, thereby forcing the FBI to fire back. A suicide by cop, exactly what it was. Trying to force the FBI in front of the world press to be humiliated, to be criticized for shooting women and children and shooting people that were there at Mount Carmel. And then if that failed, they were going to kill themselves. They even went around selecting their friends as to who was going to be the person that was going to kill you. They went around and rehearsed how they did it. This, again, is based upon the testimony. They went around and rehearsed how to do it. How many people can die on a hand grenade? Should we have 3 of us, or should we have 4 of us standing around when the hand grenade is pulled? Who's going to pull the pin? That was the degree of rehearsal. It got to the point where they finally even got down to say goodbye to each other. They gathered in the cafeteria on about March the 2nd or 3rd. They had religious services to the extent they had. They sang songs. David all of a sudden sent out messages. He was feeling better. And that's when the message came that God said to wait. Now, no witness testified that God told him that he was going to surrender. All he told him to do was wait. There was never any testimony that David Koresh intended to surrender. Likewise, during the 51 days of the siege, there was never any indication that David Koresh was going to surrender. There was more negotiations, hundreds of hours of negotiation tapes, all of which have been released to the public. There were hundreds of hours of Title III, and I understand now that the Department of Justice has finally obtained a court order that permits those to be released to the public. Those indicate that there was no intention to surrender. The only people who came out of Mount Carmel during the 51 days were people that David Koresh sent out. He selected for various reasons to go out. An example, Kathy Schroeder, the lady who made a deal with us and testified on our behalf. She was sent out because she was a sinner. When David Koresh was weak, she had smoked cigarettes, she had drunk alcohol, and when he got his powers back, and when we recovered his powers, he became incensed over that. He called her in and he told her. He'd already sent her children out. They were going to stay in the world and not go to heaven. And he told her, you've been such a sinner that you're going to interfere with my chances to get my followers into heaven. And so therefore, I'm going to send you out, and you're going to stay here while I die. And then once I die, then I'll come back and get you. But because of that, because I can't risk your sin jeopardizing my mission, I'm going to send you out. That's the reason that the negotiators, no matter what they thought, never could understand why they couldn't get more. And the reason they couldn't get more was that any time they got something, it was because David Koresh decided they were going to give them to him. The Branch Davidian started the fire. We proved so conclusively that the Branch Davidian started the fire that at least two defense counsel conceded it during closing argument. We proved it through direct testimony of experts. We proved it through a multiple type of experts, fire marshals from all over the nation that did an investigation, a PhD professor who you'll hear from. Watch his tape. It's a great tape, who came up with a fire analysis. We proved it through the scientific evidence showing the scattering of fuel throughout the compound. We proved it through the Title IIIs. They were the ones that were heard on Nightline the other day. Mr. Rivas, I think, describes them as being murky. I'll be truthful to you. I heard it the first time I listened to it. If you didn't hear it, go back and listen to Nightline again. You can hear the instructions, even through the gas mask, even though it was too difficult to hear on April the 19th. When you go back now and listen to it, you can hear the instructions. You can hear, spread the fuel. Have we spread the fuel yet? Have we saved some? Where you can also hear some of the passages where you say, we set the fires when the tanks come in. This was the type of evidence and the degree of evidence that we used to affirm or to prove those particular matters. And then lastly, of course, it was confirmed by the presence of the forward-looking infrared camera that was located on the plane above. This is another area where we have myths that grow. One of the myths is, well, the FBI must have known there would be a fire, or else they wouldn't have put that camera up there. This operation started in the dark. This operation started before sunrise. That camera was up every night during the 51 days. It would circle. It would make those photographs. It would follow that particular area, and they were trained observers. What better choice to the FBI than to leave that camera up there, even though it did go into the daylight? Not because they thought a fire was going to start, but merely because they wanted the extra set of eyes that were up above. What about the still pictures that were taken from the plane above? Take a look at those. Examine them. It shows where the tanks were. It shows how far they went inside. One of Mr. Rivas's suggestions is that the boom operator, the tank operator, went in and knocked against that bunker that you see on the later portions and knocked down some stones and killed the people inside. Outrageous. The boom operator completely ignores the testimony of the operator, a Marine Corps veteran who was trained in the Marine Corps to operate this very vehicle, who very carefully goes inside and never goes through. Look at the floor plan, even in Mr. Rivas's book. There's a room, a hall, a room, and then the bunker. Never goes past that very first room. Never penetrates beyond that first room in order to inject the tear gas in there and to open up the various sides of the wall. And one thing you need to remember on that, too, the testimony of all the survivors that came out, all but two did not, but all but two of those survivors came out through holes that had been made in the walls by the FBI tanks. Two came out windows, but the rest of them came out through those holes. That was part of the reasoning behind it. There was testimony as to what the reasoning was, why that operator used his skill to go in there and open up that particular area, and it was to open up the area. It was to provide an escape route. This is the kind of myth that we're concerned about, and this is the kind of myth that Leroy and I would like to be here. We also established, for instance, that the survivors that came out, their clothes smelled of accelerants. They smelled of diesel fuel. They smelled of lantern fuel. They smelled of lighter fluid. And then the laboratory later came back and confirmed that they had done it. There was more suggestion or surmise that there's some sinister purpose of the tank coming down near where the bunker is. If you'll see some later film, there's a picture of the tank down there with his blade out. That ignores, again, the testimony of the operator, who testifies concerning why he was there and what he was there for. He knew that he was in danger. He knew that if that building fell over on him, he was, yes, sir.
Your time has expired. If you could kind of wrap
I'm sorry, Your Honor. Sorry, Mr. Chairman, I didn't realize that. We submitted our other matters in there, and I think the most important thing to remember is that Leroy and I, to the extent that we can speak for anyone, speaks for the hundreds of law enforcement persons, state, local, and national, whose lives have been affected by this matter, who are not the beast. They're not out they're not out to inflict any damage. They're not out to injure anyone. They're your brothers and your sisters and your mothers and your fathers and your sons and your daughters, and let's not forget that during the next few days.
Thank you very much. We have a problem here. You've been hearing some bells. We have 2 votes pending, maybe 3, and the process means that one will be for 15 minutes, which we're going to immediately move out to do. There may be 2 5-minute votes after that. Procedure is that we'll recess until 5 minutes after that series of votes. So if you'll be patient, I appreciate that. We look forward to asking all the panel their questions. Recess. Thank you.
Till when did you say?
We'll recess till 5 minutes after these series of votes.
This is the first day of coverage of Waco hearings before the House Government Oversight and Judiciary Committees. We'll continue testimony in a moment, but first, some program information. America Online subscribers can participate in a computer chat room with Republican Senator Thad Cochran of Mississippi, Thursday night at 8 p.m. Eastern Time. If you're connected to AOL, you'll find the chat room using the keyword C-SPAN.
If there's a public affairs event in your area you think we should cover, call the C-SPAN events line. Our telephone number is area code 202-626-7963. You can also fax us at area code 202-737-6226 or contact us by email. Your message should include as much information about the event as possible. The name and phone number of a contact person would be appreciated.
Follow proceedings in the House and Senate with our 1995 Congressional Directory. It includes biographies of members, committee assignments, and information about C-SPAN programs. The cost of the guide is $12.95, including shipping and handling. To order, write C-SPAN Publications, 1616 Main Street, Lynchburg, Virginia, 24504, or call 1-800-523-3174.
We continue now with the first day of Waco hearings before the House Government Oversight and Judiciary Committee. A note, 45 minutes into this portion, there is some graphic testimony.
Subcommittees, please come to order. The procedure that we're going to use here on questions that the subcommittee and committee chairs and ranking minority members will each have 5 minutes to ask questions. And the chair will begin. Mr. Revis, did I pronounce that right? Is it Revis or Revis? Revis. Let me just ask you, you've been researching this project since 1993, 2 years, and what do you believe, and this is a real easy one, but just in 30 seconds or less, what would you believe the most important thing we can do to pull in these hearings that would come out of all these hearings?
I think the most important thing would be if you could declassify or give to the public and the press all of the documents that we haven't been able to get at. For example, all of the Raiders gave statements to the Texas Rangers. The federal prosecution has those statements. Nobody will turn them loose.
I have to admit we've had some trouble also.
I understand y'all have. So first of all would be the documents that exist. They shouldn't be kept secret. It's been 2 years. There's no longer any good reason for that.
Thank you. Mr. Yan, just a couple of questions. When you were prosecuting the surviving Davidians, am I correct that in addition to what you have already testified to, that you charged 11 of them with murder?
That's correct.
And 11 with aiding and abetting murder?
A conspiracy to murder, and then the actual aiding and abetting the murder itself.
And 10 were using or carrying a firearm in the commission of a violent crime?
I'm going to accept your word of that, Chairman. I don't remember the exact number on that.
But approximately 10?
Yes, sir.
Okay. And is it true that the Davidians stated that they were acting in self-defense?
That was a charge that was given to the jury, but there was no evidence to support that charge. There was no evidence that they were afraid of ATF as far as being physically afraid that a particular ATF was going to fire at them or anything like that. The court bent over backwards and gave them a self-defense charge.
But they basically, that was their basis. I mean, they said that they were acting in, it is true that they were acting in self-defense.
That was one of their defensive claims, yes, sir.
Is it true that no Davidian was convicted on the counts mentioned?
That they were not on the murder and the conspiracy murder, that's correct, yes, sir.
Thank you very much. I wanted just to ask you that during the days immediately after the ATF raid, a shooting review is conducted which involved asking questions of all ATF agents involved, and at some point that review turns into questions that could produce information that's helpful to understanding exactly what happened. The Texas Rangers state, and I'll refer you to Treasury Bates number 14137, that you, Mr. Yan, wanted the review cut off. I guess my question is why would you, of all people, want to cut off a process that was designed to get at the truth?
I think that was a mistake, Mr. Chairman. I didn't come on board until April the 1st, and it's my understanding that there was a decision made to stop the Treasury review and let the Rangers do all the investigation and gather their information. But I think that was a mistake on the report because I had no one consulted me about cutting off a Treasury review. So I think that might have been a mistake. Now, if perhaps they talked to the U.S. attorney who was on the case prior to April the 1st.
Do you have any knowledge of any other federal prosecutors cutting that off?
No, not direct knowledge, no. But I would say perhaps they talked to Mr. Ederer. That's the only thing I could think of.
Okay. Let me move on to another question. Let's see. We found a set. We had thousands and thousands of pieces of paper to go through, and much of it was very unorganized. Found a set of handwritten notes that looks to me to be from someone at the Treasury Department. They read as follows: 1:20 p.m. per Tony, Ray Yan advises us to tell Ron Noble not to open the envelope from Houston Chronicle. Contents are from illegal intercept, lock in safe and keep, DOJ researching possible violation by paper for printing and distributing. I couldn't help but be intrigued by what this Waco-related note means. Could you shed some light on what was in this mysterious envelope and why Ron Noble could not open it and why was it being locked in the safe?
Yes, sir. We subpoenaed and obtained from Mr. Maloney, the TV cameraman, or actually I believe it was the other one, his total tape. On his total tape, they had a scanner that was scanning cellular phones, which is probably an illegal interception of those cellular telephone conversations. If we had permitted that to be circulated around, that would have been in itself illegal in terms of spreading it around, even letting Mr. Noble listen to what his agents were monitored saying. That in itself would be illegal. So we stopped the spreading until we could edit out those portions of the illegally seized cellular phones. That investigation was referred to justice, and I don't know what they ever did in terms of whether or not that constituted a illegal wiretap by the press or not. I don't know what the final outcome of that was.
This is the last one, just a quick one. If you knew all the bad things about David Koresh, why didn't you arrest him in town?
Well, I wasn't there. I didn't come on until April the 1st. I think what you need to do is address that question to Mr. Aguilera, who's going to be here, Mr. Johnson, who will. There's no obligation, once the warrant is issued, there's really no obligation to do it as a matter of judgment. and we're willing to admit there were some mistakes made in judgment in this particular matter.
Thank you very much. I'd like the chair now yields to my friend Karen Thurman, the ranking minority member from Florida.
Good afternoon. Mr. Rivas, you keep talking about these documents. Can you give me a better sense, since you'd like us to ask a question on this, of what it is and what documents is that you're still looking for? I saw your interview on TV the other morning that had suggested that now, since then, you've gotten the tapes. I guess since the trials, you were given tapes from the FBI. What other documents is it that you're still requiring?
Okay, the tapes, as you call them, I got transcripts of those tapes, and I got them through a process that I think was irregular. An attorney named Joe Turney, who had got them for discovery, gave them to me. No one has yet been able to get a copy of those from the FBI through Freedom of Information Act, though about 2 weeks ago, the FBI put a set in its Washington office, and you can go in during working hours and look at them. So they've been declassified to the Washington, D.C. press, which doesn't help us a lot in Dallas. But in particular, the documents I just mentioned were these. After the February 28th raid, the Texas Rangers interviewed all of the raiders, took a statement from each of them, typed it up, and we have only seen about 20 of these statements from those raiders who the prosecution thought it might call as witnesses in the trial. I tried to get the other 60 statements, for example, from the Texas Rangers. They told me I'd have to sue to get them. Let me think what else.
Could there be a reason why? Maybe Mr. Yan is a counselor. I like you, am not an attorney.
I can tell you the reasons they've given me. They say that there's a lawsuit and that they don't want to complicate that litigation. And my assessment of that is that if the owner of the Watergate building had sued Richard Nixon and we would have let him say, gee, there's a lawsuit, I can't give you any documents, history would be much different than it is today.
Mr. Yan, would you like to respond to that?
I know there's $1 billion worth of lawsuits filed against the United States, and there are exceptions under the Freedom of Information Act, exceptions that are granted by this Congress to exclude the discovery of those items that would compromise litigation, pending litigation. That's the reason until the criminal trial was over, there was virtually no discovery whatsoever. Since that time, I know Ms. Reno has given instructions to make as much as possible, but again, because of the fiscal limitations on manpower and duplication and copying and everything, there's a big backlog on FOIA requests. I was told that this delay which he's meeting is just a normal delay because of all the other people who have come in ahead of him filing their requests, and they have to be processed. You take out informants' names, you take out the names of people that were promised confidentiality, you take out privileged sources, and then you turn it over at the end. And it's just a normal process. There's no effort to conceal anything. In fact, Mr. Rivas, if he had called me and asked me some information, he prints in there that I was involved in the decision-making to inject the tear gas, and that's totally false. If he had given me the courtesy of calling me, I would have told him, no, sir, I wasn't involved in the decision-making to inject the tear gas. So it's not a question of trying to hide something. It's simply a question that we operate under the rules that Congress imposes on us.
I can tell you during the crime bill, everybody in the world wanted a copy of the crime bill. We couldn't get it to everybody either, so we kept having problems. Mr. Rivas, on page 14 of your book, you talk about the fact that the main premises of your book is that the press did not investigate the events at Waco and that only you really understand these events. Could you kind of describe for us how your findings differ from the rest of the reports or the reporters who have covered this story?
First of all, I want to say thanks for reading my book.
Well, you're welcome.
I'm always glad to meet
job.
someone who does. What happens to the press during that time, and I think most of its members will admit this to you now, is that their budgets got spent during the 51 days. The search warrant, for example, was sealed for most, if not all, of that period, so the press couldn't even find out what it was that David Koresh was supposed to have done. It had to take the word of spokesman for it. After those 51 days were over, I went down and, for example, ran into the transcripts of all the telephone calls from Mount Carmel to the FBI. And for a year I had those, and I told people I had them, and nobody wanted them. The biggest surprise I encountered in writing this book is that I had no competitors. And naturally, my conclusions differ, or my questions differ, because I learned a lot more than they did because they abandoned the story when the building burned down. Now, of course, there were some who didn't abandon it quite as quickly as others, but in general, this represents a major failure of the press in our country.
Mr. One, another question that has been kind of surrounding this has been about whether Koresh was having sex with girls as young as 12 and 13 years old. What evidence is there that Koresh was having sex with children?
We were ready to present testimony of for instance, the midwife who had given birth to some of the young girls. We felt so strongly that, like I said, it was our plan to take his DNA upon leaving the compound and take the DNA of the children and prove it up. We just basically, I've even heard Catherine Manson, one of the ladies that was mentioned, the survivor that came out. She was interviewed on the Waco paper, and she admitted one of the girls was 14 years old when she gave birth to one of David's children. So it was a kind of a secret, but it wasn't a very closely held secret from within the members of the message.
Thank you.
You're now recognized as Chairman McCollum of Florida.
Well, thank you very much, Mr. Chairman. Mr. Yon, I want to ask a question of you. First, with regard to the trial itself, in terms of testimony, was there any testimony at the trial about ATF officers carrying firearms while they were in helicopters on the day of the raid?
Yes, that they were carrying firearms and that they had been cleared. That the rules were that they could not have a round in the chamber, and that was the rule that the pilots operated under as they flew toward the area.
What was Kathy Schroeder's testimony at trial relevant to the helicopters and firearms?
She was on the front side of the building, and she didn't have any personal knowledge, any direct knowledge.
That was her testimony at the trial itself?
Yes, well, that's if she was even asked, that would have been her answer. I can't remember now whether or not she was even asked, because she was at the front side of the building during the whole time of the transaction.
Well, we just had a lot of conflicting testimony about helicopters, as you know, and I wanted to find out what had come out at the trial. Mr. Revis, you have stated in your book and in a couple of the comments that you made here quite a bit about the aftermath of the siege, or I should say aftermath of the 28th of February, the siege and the fire itself. You didn't get to testify much about that today, but Mr. Yan made a big point, as I gathered from his testimony, that there was a lot of planning going on and that David Koresh never intended to surrender. As I recall, you got some indication that David Koresh would have surrendered right along. I'm sure you sat there with me listening to Mr. Yan's testimony, and I wondered if you could respond to us what your investigation unearthed and why, if you do disagree with Mr. Yan on that point, why you disagree.
Right, Mr. John said this morning that there was never any testimony about Koresh planning to surrender, and nothing in the tapes or transcripts. In the transcripts on the 14th, 15th, 16th, and 17th of April, the 18th as well, there's discussion between Steve Schneider, David Koresh, and several FBI negotiators, in which David says, as soon as I get the seals written, I'm coming out. This was a big decision for him, incidentally, because he believed his doctrine should never be written down until April the 14th. And the FBI negotiators say at one point, can we go to the bank with that? And Koresh says, yes, you can. And at another point, they say, well, will you send us the seals out as you finish them? And he says, yes. My interpretation of those transcripts is that Koresh thought he had an agreement to surrender when he was finished writing those documents.
Well, now, the other side of that coin is the impression being given maybe that Koresh was just simply lying all along, that he was just playing people along outside. I mean, I hear that throughout some of this from the ATF side and the FBI side of this. Is that not your impression?
You know, when a man is dead, we can convict him of anything and accuse him of anything. I believe that David was being honest, because always before he had said, my message cannot be written. God does not want it written. The Bible's already written, and that's all we need. All of a sudden, at the end of Passover, on the 14th of April, he decided that he had to write his message. I think he was persuaded by Tabor and Arnold, two theologians. But we can't know. we can know that he said that. We can't know now what would have happened because we didn't wait to find out.
Would you care to give us your criticism, if there is any, of the final day of the fire? You said you didn't have time to give that, and what led up to it?
I think the best information on this point, and it supports what I say in my book, is that the methylene chloride that was injected into Mount Carmel with the ferret rounds, that its vapors are flammable. There's a long article in the Sunday issue of the Los Angeles Times by Glenn Bunning that has more expert information than my book had. It establishes methylene chloride is dangerous. You should not throw it inside of buildings, its manufacturer says.
What about come along? You had an agent come along. You said that after he had his little period of time that things really changed when the FBI took over the negotiations. Can you tell us about that?
Yes, his name was Jim Cavanaugh. I can now say that I'm away from Simon & Schuster's lawyers.
All right.
I think he did a good job, and Koresh and Schneider were greatly displeased when he was pulled off. He did a good job because he let them lecture him on theology, and they thought they were making a convert out of him.
And after he was pulled off?
They threw a fit because they felt he had been pulled because he had listened to them.
And during the time he was on, quite a few people were let out, is that right?
That's right.
Thank you very much. Thank you, Mr. Chairman.
Thank you. The chair now recognizes the ranking minority member from New York, Mr. Schumer.
Thank you, Mr. Chairman. First, Mr. Yan, have you read Mr. Revis's book?
Sorry, I have not.
Okay, well,
I read excerpts of it and portions of it, but not the whole book.
Okay, from the excerpts you have read and the testimony you've heard today, how would you characterize the accuracy, the factual accuracy of Mr. Revis's beliefs and observations about what the incident in Waco?
The ones I have direct personal knowledge of, I know he didn't ask me about my knowledge and my involvement, my participation, but he does assert that I had a personal interest in the outcome of the trial because I had done it. The other one is for instance, he describes me as short. I'm 6 feet 2 inches tall, and maybe by Texas Ranger standard, that's short, but an ordinary person, it's not defined as short. I have not had a chance to go through one by one, but like so many of these, not so many, but there are some things that are grossly wrong, some things that are slightly wrong, and some things that are correct. And I really couldn't give you...
But does it have a series, or at least the parts you know, a series of inaccuracies?
Yes, sir.
Thank you. Now, this is an AK-47 rifle that's converted into a machine gun. Let me ask you, Mr. Yan, do you have any doubt that there were illegally converted machine guns like this in the Davidian compound?
None whatsoever. In fact, we found two, one in a car and one in the ashes, both of which still fired.
No doubt at all. And second, from your knowledge as a U.S. attorney, do you believe that it is ever appropriate to answer a federal warrant, no matter how poorly drafted, with a machine gun?
I don't believe that. I believe that that's the purpose of going to court so you can resolve it. That's the purpose of having excellent attorneys like these defendants did eventually on the trial, so that you can make that determination.
Thank you. And it's my understanding, by the way, and we'll bring this out later, that none of the excellent attorneys, and he had some of the best in the Southwest, that none of the excellent attorneys that represented the people ever challenged the legality of the warrant. Is that correct?
No, the warrant itself, they did not. They challenged the knock and announce provision. There was a hearing on that, and the court found that it had been complied with.
But not the legality of the warrant.
That's correct.
And would it, if they thought the warrant was illegal or something was wrong with it, would it not be an ethical violation for them to fail to challenge it?
I never like to say an ethical violation because you don't really necessarily force an attorney to make that decision. But these attorneys were good attorneys.
Thank you, Mr. Yan. I have no further questions.
Okay, the Chairman Klinger, Chairman Hyde are not here, so we'll move on to...
Mr. Chairman, would it allow me in the rules, if I didn't use all my time, to yield to one of our members? Is that...
Well, if you do that, we will then have to use... I just passed over 2 of our members, and...
No. I don't mean extra time. I mean the remainder of my 5 minutes. Oh, okay.
I mean, we're trying to be fair, but...
All right.
I passed over...
We will try in the next round to give Miss Gene Taylor his time. Thank you.
Chair now recognizes the full oversight ranking minority member, Curtis Collins of Illinois. Mrs. Collins.
Thank you, Mr. Chairman. Mr. Yan, gun control opponents have made the serious charges that 4 ATF agents killed in the raid were shot not by David Davidians, but in fact by other ATF agents in what is called friendly fire. I'd like to ask you to describe the evidence of exactly who shot the 4 ATF agents.
We did a great deal of research and work on that particular matter, ma'am, because we figured the friendly fire allegation would be one of them. And in fact, we found an instance in which one of the wounded agents, totally removed from the deceased agents, had in fact probably been hit by one of his own people during the course of the shooting in that little room up there. Every piece of particle or fragment that was recovered from these deceased agents was examined by our firearms expert and compared against the bullets. We took bullets off of every ATF gun that was out there, whether they were fired or not, and compared them against the fragments. There was absolutely no ATF gun that was out there, whether they were fired or not, and compared them against the fragments. There was absolutely no comparison whatsoever that would place it with ATF. Moreover, many of them were killed by AK-47 fire, and the AK-47s were only handled by or had by the Branch Davidians that day. There were no U.S. AK-47s at Mount Carmel.
Could you tell me what evidence you have that David Koresh was actually abusing children with the acquiescence of their parents?
We had, yeah,
At
trial we had none. We were trying to introduce that evidence, and the court held that because Koresh was dead, the probative value was outweighed by the prejudice. I understand there perhaps will be the best case we had may testify at this hearing later on, and I don't want to get in a position of embarrassing a juvenile by making some statement, but the best we had, I understand, will be testifying.
Well, the NRA and the committee's Republican staff have attempted to x-ray the 48 illegal weapons, and apparently they believe that some news tests could prove that these were not illegal weapons. Now, could you describe the methods that were used by the prosecutions to determine whether the weapons were, in fact, illegal, Mr. Jones?
We used Special Agent James Cadigan of the FBI, and I understand he's also scheduled to testify, who had to be one of the best firearms experts I've ever dealt with. I think he had 12 to 15 years experience. What he did was go through the firearms that were fortunate enough to be intact, and he disassembled them, examined them, found out how they had been made. He read the literature. We had the books that they had purchased on how to convert these weapons. He examined the tools that were used to convert these weapons, and then he went back and made basically a firearm by firearm examination of the superficial things that he could see, because these guns were all burned and they were all encrusted with ashes and everything else, so he could not disassemble them. But he went through and looked for the 5 or 6 features that he found common on all the working automatic weapons that were seized at Mount Carmel. And that's what he based his opinion on. In fact, he was very conservative. There were probably some other weapons that someone else may have estimated to be automatic, but instead he limited himself to the ones that he found all of those particular portions before he made his opinion, and that was a total of 48.
Mr. Chairman, now the green light is still on. Would I be permitted to yield to Mr.
Yes, you can.
Oh, okay. I'll be glad to yield to Gene.
Yeah, what we did, just so everybody understands what we were trying
No,
to
you're talking
figure.
on my time, Mr. Chairman.
I won't penalize you. I'm going to try to give you something if you be willing to accept it.
I'll accept it.
Okay? This is really straight stuff now. In the interest of being fair, we just had another huddle here. We missed our 2 chairmen weren't here, so they can't yield their time. We went back over and talked again. Mr. Schumer's comment, he does have a minute left that he can yield. You can take what you want to do with your time as well. So we're doing everything we can to the best of our ability to give you every edge we can possibly give you. Yes.
First, I want to thank you for that fairness, and second, would it be permissible for me at this point, as opposed to later, to yield my additional minute to Mr. Taylor?
You can do anything you like.
I yield my remaining time to Mr. Taylor as well.
Thank you, Mr. Chairman.
I want to thank my colleagues. Mr. Rivas, I'm somewhat shocked by your statements implying, in effect, that Mr. Koresh was a normal Christian preacher and that he was just going about his normal business as a gun dealer. Do you know of any other Christian churches that buy and sell guns as a business? Is this what Billy Graham or Pat Robertson or even the Pope of the Catholic Church does? Do you know of any other Christian religions that compile a hit list, as Ms. Bunns says in her testimony, of former cult members that should be eliminated. Do you know of any other Christian religion that keeps people for 3 months at a time without their consent? Again, Mr. Chairman, as I said earlier, I don't think we can start on the day of the raid. I think we have to look at the events that led up to the raid to get a true picture of whether or not the people who are paid by this government to enforce the laws that this Congress passes, were acting properly. I'd like you to answer that.
I think you mischaracterized me. In the first place, I don't know what a normal Christian preacher is. And I think if I did, I'd have a lot of denominations on
How
top
about
of
answering
me.
the other specific questions?
Okay, but secondly, I don't, how do you say? I say that David Koresh was guilty of arms violations insofar as I can see, and that he was guilty of statutory rape, and that there were grounds on which to arrest him. Nothing I say in my book goes contrary to that. All I was saying in my earlier testimony was that he did not invent his religion. He inherited it and changed it within a tradition. He was not a Charles Manson who cooked up a religion
Mr. Reeves,
out of nothing.
if I may, does your book, and I have not had the opportunity to read it, you know, I understand that the Presbyterians have something like a parish council that chooses the new preacher. I'm a Catholic. The bishop sends us our priests. Tell us how Mr. Koresh got rid of George Rodden, and if this is the normal routine within the Branch Davidians for one preacher to succeed another.
Your time is up. If you could just kind of
I'm
pull it together.
asked the question.
Before 1940, the Davidian Seventh-day Adventist Association, Koresh's predecessors, adopted a set of rules which says God appoints our prophet. Now, I'm not sure how you know who your prophet is when God appoints him, but Koresh's followers said God had appointed him, and George Roden's followers, of which there weren't many, said George had been appointed by God. And what happened ultimately was that George didn't pay the back taxes on Mount Carmel, and David's followers did. So they took possession of Mount Carmel. Now, your reference is to a gun battle.
That's correct.
Where David and them went to shoot a picture at Mount Carmel and wound up in a gunfight with George Roden, who was wounded in the thumb. David and his people were tried. All of them but David were acquitted, and the jury hung in regards to David.
Is that the normal procedure for that church, for one preacher to shoot at another?
I don't, in that church, no. It had never happened before, and I don't guess it would ever happen again.
Time has expired. The chair now recognizes the full judiciary ranking member, Mr. John Conyers from Michigan.
Thank you, Mr. Chairman. We've got some conflicting testimony here about who David Koresh was. And it's not at all clear to me what kind of picture is emerging. We find that conceitedly he's probably committed crimes against minors, young girls. He's violated gun laws. We have a curious picture emerging here. And I'd just like to inquire of Mr. Rivas, who's been pretty helpful. Did you state in your book at page 122 that you thought that the ATF was seeking to enforce unconstitutional firearms laws?
I think what you'll find in that chapter of my book is that I found a scholar who studied the constitutional history of firearms laws and whose opinion is that they may not be constitutional. I'm not a judge and I don't know. I was quite impressed to find out that that argument could be made and thought readers deserved a chance to see it.
Well, now that you've studied it and written and promoted it, what do you think now?
Whether or not they're constitutional?
Aren't you worried about that? Yeah, whether they're constitutional.
Tell you what.
I mean, is it okay for everybody to carry automatic weapons and defend themselves on the basis that they're unconstitutional?
No, on
idea I'm
given
reading
the present
in your
state
book.
of the law, it's clearly not.
Thank you very much. Now, did you state that in your book anywhere?
Did I state what?
What you just said. Namely, that it is not constitutional to carry automatic weapons.
I said it was illegal.
Yeah, in your book?
Sure.
Here.
I just said,
well,
here I just said.
Well, at page 120, I know what you
Show me
said
the line.
here. Just a moment. If the findings of these professors are trustworthy, the laws that the ATF sought to enforce at Mount Carmel on February 28th were unconstitutional.
Right.
Quote.
If the findings of these professors are trustworthy, that is a question to be litigated in the courts.
Okay. Page 293. The prosecution heaps of evidence also included what appeared to be illegal homemade silencers for rifles and 48 semi-automatic rifles that had been converted to automatic fire. Does that concern you about being unconstitutional? That's a violation of law, isn't it?
That's certainly what I say.
It's certainly what you say here. It's not what you said in the book.
No. In the book, I was reviewing the work of a professor who argues that these laws aren't constitutional.
I get it. I understand. You've learned a lot since you wrote the book. That's what I'm beginning to understand. And I'm glad that we're kind of getting this down to some little finer points here. I mean, it's nice to write a book about what may or may not be constitutional and unconstitutional, but yet when you come here to testify, well, there's no question, now that you've thought about it, this is not so unconstitutional as you would have thought. Now, just a moment, I didn't ask you a question there. I was just reviewing your testimony. Mr. Hahn, I'd like to just invite you to tell us a little bit about this warrant. I mean, could there be any question about its invalidity?
We didn't have any question about it, sir. We looked it over. There was a lot of surplusage. There's a lot of stuff that perhaps should not have been in there. There's a lot of stuff that had I been the author, I might not have included. And in fact, there was some that was deleted before the final warrants were served. But I had no question as to its validity.
And the people that had put it together were not newcomers to this business. They'd been doing this for quite a few years, had they not?
That's correct. And I think you'll always find room for lawyers to argue one way or the other. That's what they're paid for, and that's what they're trained to do.
Finally, the dynamic entry question. I mean, was there any way we could have...
Time has expired. If you could kind of just bring it together.
I'll just finish, let him respond. Is there any way we could have avoided a dynamic entry in this case?
You're asking far beyond my capability, sir. That would be something that I would have to defer to the experts, which would either be the FBI, hostage rescue, SWAT-type people, or the DEAs, or the ATFs.
We'll get to them. Thank you very much.
Mr. Revis, did you have a chance to respond to one of Mr. Kanya's questions? I want to make sure we're fair to everybody here.
I hadn't asked him a question that he didn't respond to. I was making an observation.
You agree?
I do not agree.
Okay. Would you
Well,
like to respond?
I don't agree with the witness.
Would you like to respond? Go ahead and respond.
Yes.
Mr. Chairman, just a minute, Mr. Chairman.
I'm just trying to be fair. And
I want to be very fair, but any questions my witnesses don't answer, I'll get to the bottom of it. I don't need the chairman to help me get the response from questions I ask the witnesses. Thank you very much. And anybody else that wants to ask him about it can do it on their own time, regularly, accordingly.
I would just like to ask my colleague, in the event if the witness was cut off and didn't get a chance to respond, I just wanted to be fair and give the man a chance to finish what he was saying.
I was just pointing out to you that he did not fail to respond to any questions that I asked. I was satisfied with that.
Yes, sir.
Mr. Chairman, I think it is incumbent upon all of us to extend courtesy to these witnesses, and I don't see what harm would result or ensue if the gentleman were allowed to explain perhaps a response he didn't get a chance to do.
Mr. Chairman, since everybody wants this question that I didn't answered, I'd be delighted to invite Mr. Rivas to make any
I thank my
further
colleague from
comments he
Michigan.
chooses.
In the interest of fairness and everything, thank you very much.
I think we have to distinguish between illegality and constitutionality. I'll give you an example. One time I was convicted of vagrancy and leading a profligate life in Alabama. What I did was illegal. Later it turned out that the law under which I was convicted was ruled unconstitutional. There's always that gap. You never know when a law is constitutional. You presume it is at the point of arrest. Things are afterwards tested. David Koresh's possession of arms was illegal. Whether or not the arms laws are constitutional will be, at this point, the courts say they are. Tomorrow they may say different because of the research I cite in my book.
Thank you very much. This completes the first panel, and I thank the witnesses for coming. Thank you for your patience and all of the votes and everything, and we'll look forward to the next panel if they would move forward. Thank you. I'll yield to Bill McCollum.
If I could, I would thank the chairman of the subcommittee on oversight for yielding to me. We are going to share this podium today by prearranged agreement. The committee will be in order. And I would like to, by name, introduce the panel of the next group of witnesses who are coming forward to be our testimony for this second round. The first witness is Gerald Goldstein. Mr. Goldstein is president of the National Association of Criminal Defense Lawyers. Next to Mr. Goldstein is Robert DeCamp, president of the National District Attorneys Association. The third witness is Henry McMahon, a firearms dealer who did business with David Koresh. The fourth witness is David Thibodeau, who was a resident at Mount Carmel throughout the siege. The fifth witness is Kiri Jewell, who also was a resident at Mount Carmel. And our final witness on this panel is Louis Barber, a former lieutenant with the McLennan County Sheriff's Office. Now, if each of you would stand, I'm going to have to swear you in at this point in time according to our procedures. You'd raise your right hands. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please, the record will, you may be seated. The record will show that all answered in the affirmative. At this point in time, under the rules that we've unanimously agreed to do in this joint committee, I yield 15 minutes to Mr. Barr. Mr. Barr?
Thank you, Mr. Chairman. We have the names in the proper locations there?
No, that's the clerk's. Well, I think we do have a little reversal. Let's see if we got it right here.
Is this Mr. Barber? Thank you. Mr. Thibodeau.
Excuse me, before we get started, is Mr. Barber here with us today? Did I miss him as a witness? We asked him to come forward, and apparently he is not with us today. Is that correct?
These are our witnesses.
Well, we apparently are missing Mr. Barber from this panel for whatever reason.
Who's the gentleman sitting next to
Could the gentleman sitting next to Mr. Thibodeau and Miss Jewell tell us who you are, please, sir? That's very good. We're happy to have you.
Mr. Chairman, I couldn't hear that.
Mr. He is Kiri's father. Would you turn on the microphone and put that in the record, please, sir?
My name is David.
You need to turn it on. There's a little flick right under there. To the forward. There you go.
Okay, thank you. It's working now. My name is David Jewell. I'm Kiri's father.
Thank you very much. Apparently, we are missing Mr. Barber, and we don't have him here, so if we get a chance to bring him up on another panel, we will, but otherwise, please, Mr. Barber, proceed.
Okay. Thank you, Mr. Chairman. Mr. Thibodeau, if you could please, over here, to your left. Thank you. Appreciate your coming here. If you could please recount very briefly the extent of your knowledge of the compound at Mount Carmel. How long were you there and in what capacity, please?
I met Koresh in approximately 91, and I had the opportunity after about 3 or 4 months of getting to know him and some of the people of going to Passover of 91, I believe it was, in Waco. I was there for about 2 or 3 weeks, and then I went up north to Maine, and then I went back to California, where David had a property there, and I spent some time there. I also had an apartment at the time, and I was between the two. And then finally they decided they were going to move back to Waco for a while. So I went with them at this point. I was becoming involved in the music and the spiritual teachings, and decided to move. I was there for some time, and for the next couple years was on and off between California and Waco.
Were you familiar with Mr. Koresh's daily habits, what he did?
Yeah.
Including on what occasions and under what circumstances he would leave the compound?
Pretty much so. I mean, I lived with him on a daily basis, on and off. I mean, you know, I had certain things that I did. I was really concentrating on music, and I obviously would not be questioning him when he would go to town and things, but there were times when, you know, I would go various places with him. So I guess yes.
Okay. Was there any regularity to his leaving the compound? Did he leave certain days of the week, certain times, or was it sporadic?
It was sporadic. I mean, there would be times when he would not leave at all, when he would just stay in and give studies, and there would be other times when he would leave. But it was, he left frequently.
Would that include during the 2 or 3 months prior to the raid in February? In other words, during the month of February and January and then December of 1992, did he leave the compound on numerous occasions?
Right before the, I'm sorry, was it 2 or 3 weeks before the raid, or?
During the 2 or 3 months
Yes.
before the raid?
Yes, he did. Yes, he did.
Okay. Do you recall, or do you know what was the last time he left the compound?
I recall that approximately 2 weeks before the raid, he was going through a period of time where he wanted to get back into health and back into shape. And so he would go out running, and some of the guys would go jogging with him. And he would go up the driveway to where the I believe it was the Double E Ranch Road, the dirt road that was in front of the building. And he would jog directly in front of the 2 houses that are across the street. One, of course, was the surveillance house, all the way down to the stop sign, maybe about a mile or so. I'm not really sure what the measurements were. And then back. And then usually, you know, some of the guys would come on the property, and, you know, we do some jogging on the property as well. And I know that he went to town infrequently, but still went to town on a number of occasions. I guess one thing that I could try to refer you to is that I remember during the course of the 51-day standoff, when the FBI, I believe it was the FBI initially, said that he never left the building. You know, he never left. We couldn't possibly have gotten him. I remember the Waco Tribune-Herald and some other media came forward because a number of people within the community of Waco had come forward saying that they had seen him in their places of business just days before the raid. I believe one was Chelsea's Bar and Grill, and that's the only one that really stands out. But I remember a couple of businessmen from Waco came forward saying he was in my store just last week or just the other day.
When he would go jogging, was this at night or during the day?
During the day.
Would he make any effort to hide the fact that he was leaving the compound to go jogging?
No. When you go jogging with a group of 5 or 6 guys, I don't think you can really conceal that.
Okay. Are you familiar, Mr. Thibodeau, with the affidavit in support of the search warrant in this case?
I have read it, but I'm not that proficient with all the technicalities in it.
No, I understand that, but you have read it, you're generally familiar with it?
Generally, very generally, yes.
Do you recall it as being a rather lengthy document?
Yes, I do.
Do you recall it as being a document that had all sorts of stuff just kind of thrown together in it?
Yeah, it's to me it seemed to be kind of like a press report, only in a legal document. I mean, you know, it talked about, obviously, I mean, from my understanding of the law, if you're going to go after someone for what you consider to be illegal activity, that's what you would concentrate on in a search and arrest warrant. And from my understanding is it went into the wives and the different aspects that have been covered today of certain aspects of child abuse that's trying to be proven. So I guess that was kind of irregular. I remember one thing that kind of stood out, and it only stood out because it was pointed out to me later, is I believe, if I'm correct, it talks about an AK-47 having an upper and a lower receiver. I think anyone who's familiar with that particular firearm knows that there is no upper and lower receiver to an AK-47, which would indicate that there was a problem with the search warrant, specifically with that one particular firearm.
Okay, you saw I forget who it was on the other side, make a big deal of holding up a weapon a few moments ago.
Actually, I think I was outside. I had to leave for a
well,
minute.
you missed quite a show. There was a weapon held up, stating it was a machine gun or whatnot, which certainly raises questions about what it's doing here. Do you recall seeing machine guns at the compound?
No. I did see AK-47s and I did see AR-15s, and there were times, various times, when different people would go out and shoot on the firing range. There were times when people that we knew from the community would come out and fire at our firing range. And to me, I'm from the East. I'm from up in Maine, and I was not raised around firearms. And to me, it wasn't something that I was really into. But being there, I did notice that there was kind of a different mentality. I don't know if it would be Texas or whatnot, but it seemed like a lot of our neighbors would come over. Neighbors from in the community would come over and fire. And it didn't seem to be as big a thing as it did where I was from, so it became acceptable.
Okay. Is it possible that there were machine guns there that you weren't aware of?
Yes, that's possible.
Okay. There was also in this rather lengthy affidavit discussion of a meth lab, which I believe, having been a prosecutor, would refer to methamphetamine, which is a controlled substance, a mind-altering drug. Are you aware of any such facility anywhere on the compound?
There was absolutely no drugs at Mount Carmel, period, other than alcohol once in a great while, when we worked particularly hard and everyone felt that they just needed to unwind. But generally, anything like that was done. There was a sobriety there that was to be practiced, and anything like that was done was on a very sporadic basis. And David Koresh was absolutely against drugs. David Koresh,
is it possible that there was a laboratory manufacturing controlled
substance
when
I was there.
That you hadn't known about?
I've been all over that property, and I never saw anything that I would even think would be. That's absolutely impossible.
Okay. Another one of the items that was contained in the affidavit referred to pineapple-style hand grenades, those that I suppose you see in magazines that people use for paperweights. Have you seen those?
I saw the casings for those, but I didn't see, an actual grenade. I mean, I've seen the casings, yes.
Okay. Were these live grenades?
Not to my knowledge.
Okay.
I mean, let me put it to you this way. I've never seen one exploded or go off, other than war movies and things like that. But I just don't know.
Okay. Do you know whether or not the compound was ever visited by agents of the Drug Enforcement Administration investigating allegations of a methamphetamine lab?
No, I don't. I know that there was some activity that took place in 1987, a few years before I was there, and it was revolving around what the gentleman over here brought up, the George Roden issue. And from what my understanding was, and this came from a couple different people that were within the community there, was that when David came out on that particular incident that was discussed earlier, he was shot at by George Roden, and some of the guys, especially I think it was Stan Silva and Floyd Houtman, were shot at, and so they were in an open field. So to protect them, David shot at George, hitting the tree in front of him. Now, what I found out later, and again, this is word of mouth, was that there were things that were found that could constitute making a methamphetamine lab. There was certain chemicals and things that were found. Now, the understanding that I have from a couple different people was that was turned over to the Sheriff's Department, and when the whole thing went to trial, the evidence of any methamphetamines somehow were not at the trial. They seemed to have disappeared. I don't know what all that means, but these are the stories that I heard from a number of different people that were around at that era of time.
Okay. Would you tell me what the term mag bag means, if anything, to you?
I knew mag bag just to be a garage that was about 2 to 3 miles away from where the building was. I know that there was a car restoration company going there. Peter Hipsman.
2 or 3 miles from the living quarters?
Yes. That's a rough estimate. I'm pretty bad with distances and numbers.
But it was quite a ways.
Yeah. Yeah.
Maybe not by Texas terms.
Yeah, by Texas terms,
Georgia
exactly.
Terms
That's what I was thinking. Yes, it was quite. It would have been a long walk. Let me put it that way. You know, you probably could have biked it in about an hour.
Okay. And what was the mag bag?
Like I said, it was just a garage where they restored cars, custom Camaros, things like this. I know that Peter Hipsman and Michael Schroeder were down there pretty frequently. They actually lived there, and Bob Kendrick for a time lived there as well. But it was Peter that did the majority of the work, actually painting and restoring the cars, and Mike did the mechanical work.
Okay. Did the term refer to anything else as far as you know? For example, a corporate entity by that name?
That's possible.
Okay. You're not aware of that, though?
No, it's not my thing.
Mr. Goldstein, if I could ask you, if you have had the opportunity to review the affidavit that I've been taking a few moments here to review with Mr. Thibodeau.
I have.
Thank you.
I have.
Could you please, we've heard testimony, speculation earlier about its sufficiency and whether or not it was subject to a successful challenge or not, and apparently it withstood at least whatever judicial scrutiny it was afforded previously. What, in your opinion, as a learned an attorney with experience in reviewing and I suppose challenging affidavits, is your impression of this affidavit?
It, like many other affidavits that lawyers that practice in the criminal courts from one courthouse to another across this country, is not terribly atypical. I will tell you that it is chock full of irrelevant, highly inflammatory material. That's not that unusual. Many of you are good lawyers. That's what lawyers usually do, is try and convince somebody of something. It definitely has matters that fall well beyond, for example, the either expertise or jurisdiction of the particular agency seeking the warrant. That is, matters of child molestation that obviously would inflame anyone that read it, just like it probably has the people that listen to this hearing. Nevertheless, they had little to do with the underlying justification for the entry. There are allegations that many of these matters are misstated. Quite frankly, one of the problems that we have is if I could tell you gentlemen anything about what we need to do, is that those of us who are in the trenches trying these cases day in and day out are gumming these law enforcement agents to death. We have been deprived of any teeth in the exclusionary rule and the mechanism that we have, the sole Fourth Amendment protection that we have to attempt to regulate these agencies. And efforts to dilute that protection is frustrating if you want to know why nobody filed a motion to suppress, I would suggest that that probably goes a long way. For example, misstatements. If there is an omission, critical omission, that would have made a difference to a magistrate, if one of these statements in the affidavit, in fact, is an outright lie, in order to get a hearing, in order to subpoena a single witness, in order to ask a single question, we've got to show by affidavit or sworn testimony or otherwise that there is a lie in the affidavit before we even get a chance to have a hearing. I wish I had 8 days of congressional hearings on every warrant that I suspect is flawed with misstatements. I've never had a suppression hearing that lasted 8 days, much less this kind of inquiry. The fact that the warrant may lack probable cause, it's a pretty close call. This one just might lack probable cause. But quite frankly, to the lawyers that were out there in the trenches trying this case, it didn't make a hill of beans. It wouldn't matter because the good faith exception allows the judge to admit evidence even though the affidavit and the warrant totally lack probable cause. That's where the problem and that's where the solution can come. Not in providing more authority to law enforcement, not in being concerned about this abuse on today, and yet passing measures that in fact apply the good faith exception that I just described from warrants and apply it to warrantless searches. Senate Bill 3, Section 507 will do away with the exclusionary rule altogether. We'll have no way of restricting and discouraging officers from engaging in these kinds of activities.
Mr. Barr, your time is up.
Thank you, Mr. Chairman.
Before we proceed further, I notice Mr. Barber has joined us at the witness table. You need to be sworn in, Mr. Barber. If you'd stand and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Let the record, thank you, you may be seated. Let the record reflect the witness responded in the affirmative. I now yield 15 minutes to Ms. Furman.
Thank you, Mr. Chairman. At this time, I believe that all of you have some testimony in front of you from Kiri Jewell. I'm going to ask for part of my time for her to have the opportunity to read into the record her particular testimony, and then we can proceed from there. Kiri, welcome, and thank you for being here. You can begin.
When my mother and I first joined David Koresh, he was still Vernon Howell, and his group was living in a little two-bedroom house in San Bernardino, California. I was 5 or 6. We lived with the group off and on there and in Pomona, California, in Palestine and Waco, Texas, and in Laverne, California. When we joined, David was planning to lead the group to Israel to retake Jerusalem. He taught that there would be a big battle between the forces of the world and David and his people. The world would win, and we would be killed, but we'd come back in a cloud and smite the wicked and retake the world. The details would change as David received more messages from God, but there was never a time when we didn't expect to be killed by the feds, who David said were Babylon. While we waited for this to happen, we built up an army for David, so the battle would be a big one and all the world would know the power of David and God. In the meantime, David was very strict about how we should live. He only spanked me twice, though I knew he spanked other people or had them spanked. He personally spanked me because I said I was going on a diet when I was about 8 years old. He used the big wooden boat oar they used for adults, not the wooden spoon they called Little Helper. The second time David spanked me and the other kids, it involved getting candy from vending machines against his teachings. Before spanking us that time, he bought an enormous lot of candy and made us eat it till we were sick. It was common for David to sleep in a bed with women and children. Sometimes I fell asleep in his room after meeting, or maybe I'd fall asleep on his bed watching MTV. I didn't even think about it because the women and girls were all David's wives, or would be, and many of the kids were his too. Even if he wasn't really our father, we were taught that he was our real father. I've slept together with him and my mom and Lisa Ferris. I've slept with him and Aisha Garifas. Aisha was older than I was. She was probably 13 when I was 6 or 7. She became one of David's wives when she was 14 and had a baby for him. Once she was pregnant, I never saw her. She was kept hidden because she wasn't an adult. David took me on a motorcycle trip with some of the guys to Mount Baldy when I was about 7. On that trip, he took me for a ride down a mountain ski trail on a chairlift. There wasn't any snow, but it seemed like we could see the whole world. That was when David said to me personally that one day I would be one of his wives. We all knew about sex because David talked about it a lot. He made us watch movies that showed sex and war like Platoon and Hamburger Hill over and over again. I was scared by the rape scene, but I would have been more scared to try to leave the room when he was there. We also watched Miracle of Life to see how babies were born. David talked about having sex with his sister-in-law, Michelle Jones, for the first time. She was young and scared. He said he got into bed with her and was trying to pull down her underwear while she was trying to keep it on. He said her heart was beating really fast. He talked about how he liked Novelette Sinclair playing with his nipples and that Janine Buns had the type of pussy that really held onto his dick. Those are completely his words, not mine. I was in the meeting at the White House in California where he told Judy Snyder to stand up and then asked the guys if any of them lusted after her. A few of them nodded. He told her to pull her skirt up. She pulled it up a little way and he told her to pull it higher. He told her higher several times before she got it up enough.
I hate to do that, Kiri, but we just realized that your testimony has very graphic material, explicit material, and you have a very general audience that's watching this, and I just think they should be warned about that fact. It is testimony of record. Your father's with you. You've been asked by a member of Congress to read it, but I think we need to be aware that you have a very wide television audience, and this is not in any way censored. So I just, as a fair warning to the public generally, I'll let the time be added.
But just ask Mrs. Thurman if you, it's your witness, do you feel comfortable?
Mr. Chairman, I have actually talked with Kiri about this, asking her if she felt comfortable in responding to this very same issue that I might have raised here. She does. She wants the story out there. She feels compelled to tell this story. These are the words and what she heard and saw during the time that she was there. I agree that they are explicit, but I think that we also need to understand who we were dealing with.
Oh,
Excuse me, I believe we have a witness here. of 14
I
years
believe
old.
it is regular. At this point in time, the questions have been asked and whatever, and the witness may proceed to give her testimony. I think we needed to put on the record more for the home audience than anybody else or whatever. But nonetheless, you may proceed, and I'll add the additional minute or two that we've taken up for this discussion. Kiri, please proceed.
Thank you. He told her higher several times before she got it up enough. Then he asked the guys, "Now do you lust after her?" Lots of them said yes, loudly. Judy just seemed shocked and embarrassed, but like everybody else, she wanted to please David. You couldn't really think about not doing what he said. My mom and Lisa and I went to Texas for Passover in 1991. David took the three of us to a motel. There were 2 chairs in the room, 1 bed that we all slept in. My mom and Lisa made soup in a crock pot. We were there for 2 or 3 days, just mostly hanging around the room. David preached to us. I sat on the floor playing with his shoelaces while he talked. We watched Ernest Goes to Camp. The cops came once and just sat outside. After my mom threw something in the trash, they checked the garbage. Then they went away. My mom and Lisa went to do a little shopping. I took a shower, and then I was brushing my hair, sitting in the chair, and David told me to come and sit down by him in the bed. I was wearing a long white t-shirt and panties. He kissed me and sat there, but then he laid me down. He took his penis and rubbed it on the outside of my vagina while he was still kissing me. I had known this would happen sometime, so I just laid there and stared at the ceiling. I didn't know how to kiss him back. Anyway, I was still kind of freaked out. When he was finished, he told me to go take a shower. I walked to the bathroom with my panties down around my ankles. In the bathroom, I realized I was all wet and gooey on my legs. That freaked me out more. I just stayed in the shower for maybe an hour. When I came out, David was in his jeans and the bed was made. He told me to come here again. This time he read to me from the Song of Solomon. I was 10 years old when this happened. I remember sitting in the gas station wondering when it would do it again. I wasn't afraid, but I was nervous. I knew I couldn't get pregnant because I hadn't started having periods yet. This was soon before I left my mother for what turned out to be the last time. I didn't tell her about what David had done in the motel. Sometime later, she said David's habit was to sleep with one of his wives, then leave them for a long time. I said, "Yeah, I know." She said, "What? Did he take you?" I just said, "Yeah." She wasn't mad or anything. I asked my mom, what would we do if we ever left here? She said, "We'll never leave," so I asked. I never liked it there, but I wouldn't leave my mother, so I figured I'd be there with her till the end. The end meant the great battle between David and his people and the rest of the world. We were always waiting for and preparing for the feds to come in. The people in the group didn't have to train for war, but if they didn't choose to, David would ask them why not. Dana Okimoto and Janet McBean were in nursing, and Janet said that maybe Janine, who was also a nurse, could and would provide cyanide so we could all commit suicide if it came down to it. It was also accepted that the best way to shoot yourself if necessary in this battle with Babylon was to put the gun in your mouth, back to the soft spot above your throat before pulling the trigger. When it was almost time for me to leave Michigan and go back home to my mom from my last visit to Michigan as a Davidian, my dad told me he had a court order for me to stay with him. I was shocked and scared. My mom and Steve Schneider were on the phone to me, telling me stuff like, "Remember little Esther," so I would remain true to David. She told me David had given beer to Rachel Sylvia, who was then 11 or 12, to soften her up. My mom said I needed to hurry up and get back there or I would lose my place to Rachel. She told me, "It's time to fight. Are you ready?"
Kiri, thank you. Let me ask you a couple of other, well, let me give you a few minutes. You want to get a drink of water? Okay. Could somebody give her a drink of water, please? Mr. Chairman, since we have a vote going on right now, could it be a possibility that we could go ahead and vote and let her have some time and also...
I'd be very happy to do that. In fact, we'll add another minute or two back to your time and give you, 10 minutes when you get back.
Thank you very much.
I inquire, I thought the time was up. How much time is remaining?
Well, she has about 8 minutes remaining on her time. The first clock went up, so there's about 8 minutes left on Ms. Thurman's time. At this point in time, apparently we have a second vote after this. This is the type of vote we had previously. We'll recess until 5 minutes after the conclusion of the last of this series of votes.
This was the first day of Waco hearings before the House Government Oversight and Judiciary Committees. We'll continue testimony in a moment, but first, some program information. C-SPAN Saturday Journal offers a look at the morning newspaper headlines, interviews with journalists, newsmakers, and legislators, as well as your comments and questions. And through July, the C-SPAN school bus live from landmark sites around Washington, D.C. This Saturday, we visit the Organization of American States. Saturday Journal at 8 a.m. Eastern Time. Here's some of what's on our companion network, C-SPAN 2. The future of affirmative action. Reaction to the President's speech today at the National Archives. Right now, remarks by members of the Congressional Black Caucus. That's followed by Republican Congressman Gary Franks of Connecticut and Republican Senator Phil Gramm of Texas. And then, a briefing by House Democratic lawmakers, including Nita Lowey of New York and Pat Schroeder of Colorado. And that's some of what can be seen tonight on our companion network, C-SPAN 2. We continue now with the Waco investigation, the first day of hearings before a House Joint Subcommittee. Chairing the hearing, Republican Bill Zeliff of New Hampshire and Republican Bill McCollum of Florida.
Hey, they got you.
This joint hearing will come to order. When we took a recess, we were in the middle of Ms. Thurman's questioning. Ms. Thurman, you have 8 minutes left. I will turn the clock on. It runs for 5 of those 8, and then we'll notify you as you get your 3 minutes down.
Thank you.
Ms. Thurman?
Kiri, let me ask you a couple of questions now dealing with some of the issues that have surrounded this case. In February, it's my understanding that you were actually, or went to Waco, actually before the February 28th. Is that correct?
Yeah.
Do you want to tell me what happened when you talked to the, was it the ATF or FBI that you actually talked to?
I don't know.
Okay. Would you like to just tell the panel what happened while you were there?
While I was there, I went to a courthouse, the same courthouse that I was in when George Roden, that whole thing with him was going on. It was that courthouse. And the only thing I really remember talking with them that stands out in my mind was they asked me about being molested, and I told them everything that I told you. And my dad and I and the agent that was with us drove around like pretty much all of Waco looking for the hotel or motel that I was molested in. And we couldn't find it because it was dark when we got there and it was dark when we left, so I really didn't get a very good view of the outside of the motel. But that was pretty much all that we did when we were there.
Okay. And then on February 28th, when the raid took place, what did you tell your father about what you thought might happen there?
I told him there was no way that anybody was going to get out. Somehow they were all going to die.
What makes you believe that?
He taught it. He told us from the beginning, sometime we were all going to die. And I didn't know when, and I didn't know how, but I told my dad the day the raid happened, none of them were going to get out.
And then you went on Donahue, I understand, and I believe that was March 10th. Mm-hmm. And what kinds of questions happened on there, or maybe what happened from there?
They asked a lot about the Star of David that everyone wore. They asked...
What was the Star of David?
It was just sign that you were in the group. I mean, that's all it was. A lot of people, there have been a lot of rumors that it meant that you were a wife, but the men wore it too, so it couldn't have meant you were a wife. I mean, but it was just signifying that you believed and that you were in it, and, you know, it wasn't anything really about the wives, because the men had them. Okay. So, on Donahue, I told Donahue and the audience that it was my belief that they were going to commit suicide, and the cult expert that they had told me I was wrong. And I told him, watch.
And then, Kiri, it's my understanding that your father actually sent a letter to President Clinton, and I believe it was March 28th, I believe. Have you had an opportunity to look at that letter?
Just briefly. My dad wrote it.
And in it, it kind of based itself on the situations that I guess he and you had talked about. Mm-hmm. Have you and your dad had a lot of time to talk and converse about what happened there?
Yeah.
So that he kind of knew what was going on. It
Yeah.
might be for our benefit, if it's okay, if we just put that letter into the record. I'll be glad to have a copy of it. I just received it
without objection
this morning. In that letter, basically, it talked about the allegiance and the possibility of them committing, I guess, suicide. Nobody was going to get out of there, but that the government needed to do something at this point, or we could even have a harder time. Kiri, do you know of any other children of your age, or maybe a little older, that were put into the same situation that you were?
Michelle Jones. Aisha Garifas, Karen Doyle. I know there are more, but this is just like off the top of my head, and I can't, it's not coming to me.
And you had said in your testimony that once, I guess, they were pregnant, they were removed from the rest of the group. Is that?
Not always. Actually, Aisha was the only one that I was around when she was pregnant. So, because I don't know about Michelle when she had her babies. But when Aisha was pregnant, I never saw her. She was kept inside her house.
Do you know why?
Because it was Passover and there were a lot of people from all over coming. And she wasn't supposed to be seen pregnant because she was young.
Kiri, tell me about the suicide stuff a little bit, because you mentioned that at the end about the cyanide and the gun. How did you know about that? I mean, was it taught to you? Did you just kind of know it? I mean, can you explain that maybe a little bit to us?
It wasn't taught. It was known. Ever since I was little, I've had big ears, and I like to learn. I like to observe, and I heard, I observed, and it was known. I mean, I just didn't think up this stuff as a 14-year-old kid. You know, it was learned.
This is your family.
Yeah.
I mean, I found it interesting in talking with you that you knew so many of the players in all of this. When I talked to you about the mailman, Mr. Jones, I mean, you just kind of responded as if you knew all about him. Kiri, why do you think it's important that you gave the testimony that you gave today? I mean, these are your...
I don't think it's right that people are getting things out of this that they shouldn't be. People are hurting, and they need to know the truth. This is my truth. It might not be somebody else's truth, but this is what I saw, and this is what happened to me. People are getting too much out of this that they don't deserve. They have not worked for any of it. It's not for them. They're making too much out of this than it should be. I just thought people should know what I saw.
Thank you, Kiri. Thank you. I'm through, Mr. Chairman.
Well, Thank you very much, Ms. Thurman. You were right almost on the money anyway without realizing it, I'm sure, but thank you. And thank you, Kiri. That was not an easy testimony, but we really do appreciate it and understand it and appreciate what you've gone through. It's very, very difficult. Mr. Schiff, 15 minutes for you. You're recognized.
Thank you, Mr. Chairman. Before beginning my questioning of this panel, I want to explain, before beginning my questioning of this panel, I'd like to explain what my point of view is going to be in these questions. David Koresh has never been a hero to me. I think it's obvious that he broke laws. In my view, if he had surrendered at some point, the greatest loss of life which did occur may well not have occurred. But the difference between David Koresh and the Department of Alcohol, Tobacco, and Firearms and the Federal Bureau of Investigation is that David Koresh was not working for the federal government in 1993. But the FBI and the ATF were all federal employees in 1993. Now, the point is that federal agencies like the Federal Bureau of Investigation and Alcohol, Tobacco, and Firearms have an accountability to the government and to the people at all times, no matter what kind of people that they are dealing with. So, in my judgment, Mr. Koresh's personal practices, however despicable they obviously were, have nothing to do with a hearing on how the Department of Alcohol, Tobacco, and Firearms handled a firearms violation case. And I want to say to you, Kiri, personally, that I'm very sorry that you were not protected from David Koresh. I'm very sorry that you were not protected during this hearing, because it could have been arranged that you testify with no cameras going if we had known what your testimony would have been. But I can only say to you, I'm very glad you weren't in that compound in February of 1993 and later when it burned down. With that, I'd like to ask a question of Mr. McMahon, if I may.
Yes, sir.
Sir, it is my understanding that you are a firearms dealer. Is that right?
Yes, sir.
Could you tell briefly where that is and for how long?
Well, I started in Gulf Breeze, Florida.
Right at the scene, though, we're talking about.
Could you move the microphone up closer, please? Yes, sir. We're not able to hear you very well. Thank you.
For how long in Waco, Texas? I'm sorry.
2.5 years. 1991 to 1993.
And you have a federal firearms license?
I did, yes, sir.
At the time you did?
Yes, sir.
And did you do business with David Koresh?
Yes, sir, I did.
And did he purchase firearms from you?
Yes, sir, he did.
Did you ever sell him any illegal firearms?
Illegal, no, sir.
Did he ever say that he wanted illegal firearms?
No, sir.
Did he ever say why he wanted firearms in the first place?
As an investment.
How can one use firearms as an investment?
The guns that he was buying would go up in value, no question.
Okay. And do you know other people who do that?
Yes, sir.
It's not uncommon by itself.
No, sir, not by far. No.
All right. And did you have a visit specifically from ATF Special Agent Aguilera in June of 1992 related to Mr. Koresh?
July 92.
July of 1992?
Yes, right. David Aguilera and Jimmy R. Skinner.
Okay. And they were investigating Mr. Koresh at that time, is that right?
That is apparent now. It wasn't at that time.
All right. And, but wasn't there a phone call between you and Mr. Koresh while the special agent was there?
Yes, sir.
Would you briefly say what that conversation was about?
Yes, sir. While ATF was there asking questions about David, they were asking questions: where did he get his money? What's he going to do with these guns? Why does he need these guns? I was asking these type of questions. And these aren't compliance check questions, and that's what he was there to do, was ask compliance. They were there to do compliance. These aren't compliance check questions. And so I was concerned that I was going to give him an answer that I shouldn't. So I called David up, and I told David they're here asking these questions. And David said, well, if there's a problem, tell them to come out here. And I said, well, hang on. I got this walking around phone. I walked back into my gun room. And there's David Aguilera sitting down. Jimmy R. Skinner is standing up to the left. And I go, I got David Koresh on the phone. And David Aguilera, he jumps up and goes, don't call, don't call. And I go, I got him on the phone. And he goes, and so I looked at Mr. Skinner and I said, well, do y'all need to go out there? I mean, you know, he's going, y'all got a problem? Come out there. And he's going, we do not need to go out there at this time. So I looked at Davey and I said, do you need to go out there? Is there anything you need to ask him? Is there anything you need to do? He said, no. And so I told David that they did not need to come out there, and I hung up.
So the special agent was directly invited by telephone to go out and see Mr. Koresh personally?
Oh, yes, sir.
All right, let me turn to Mr. Goldstein and Mr. Deschamps. There has already been substantial discussion of the search warrant in this case, and if there's time, I would like to go back to that. But before we do, I have a couple of other warrants that were issued, and warrants holding up aren't as good a photo opportunity as an AK-47, I know, but they may be more important to this case. There were also a warrant for arrest against Mr. David Koresh, a criminal complaint to go along with that. Have you two gentlemen seen all these documents? Mr. Goldstein?
I'm Mr. Deshaw. I have seen the affidavits. I've not actually seen the warrant or the complaint.
All right. Mr. Goldstein?
I have been provided with a copy of the search warrant. I have not seen the affidavit for the arrest warrant.
Well, let me tell you, the arrest warrant says that it's arrest warrant to United States of America versus Vernon Way Howell, a.k.a. David Koresh, and it gives the number of the Western District of Texas, and it charges him with the following crime, and I'm reading now. It charges him with the lawful possession of a destructive device. Have either of you ever heard of a crime called the lawful possession of a destructive device?
I would suggest that would not be a crime.
Does the gentleman have
Is there a parliamentary inquiry here?
Parliamentary inquiry. Does the gentleman have a complete copy of the warrant?
As far as I know, I do.
Apparently, he does.
I do.
So, if you two want to refer to it, you can, but it's the gentleman's time.
I have a copy that says, the letter N is there, and it looks like the U is not copied. So that it looks like it's unlawful possession on the copy I have.
Well, in other words, there's a reading of some of them that think this unlawful possession is actually printed on there.
All right.
Well, it's
Let me
a
go
parliamentary
on then.
inquiry, but
It's not on my copy, Mr. Chairman. It says lawful possession of
you
destructive
have an additional minute added back to your time,
Let
Mr.
me
Schiff.
go on then to the statute number. It's presumably, obviously, it meant to say unlawful possession. But let me go to the statute number. It says, in violation of 26 United States Code, Section 5845F. Are either of you gentlemen familiar with that particular section of the United States Code?
I am not.
I've read that statute.
All right. Are you aware that that section does not create a crime? It creates a definition of a destructive device, and the actual crime of possession of that device illegally is 26 United States Code 5861.
You are correct. I believe the citation is to the definitional section of that statute.
Now, my point is this, assuming I don't have a miscopied section there, that I've read the section of the code properly there, I'm making the point that isn't it rather sloppy law enforcement work to put the wrong section of a code into a warrant for which somebody is about to be arrested? Mr. Goldstein, either one of you first.
No question it's sloppy. I would suggest that on day in and day out, courts affirm arrests of individuals, even though the citation to the code is wrong. Even in convictions are even upheld when an indictment contains the wrong citation.
I wasn't asking you if it was legal. I was asking if it was sloppy.
Certainly sloppy.
All right, Mr. Deschamps, do you have a view?
Well, I'd have to say that it's sloppy, although lots of times problems happen with in transcription by secretaries and others, and it happens all the time, as Mr. Goldstein has said.
Well, what I'm getting at is, that's practically the first document in this whole set of events, and I'm suggesting that starting with the documents and point by point, one can see that law enforcement at various times may have been doing a questionable job. And I'd like to go back to the search warrant.
I would suggest that if they had spent as much time worrying about the warrant as they had been amassing military-type equipment to execute the warrant, they probably wouldn't have made those kinds of mistakes.
Well, let's talk about the warrant a bit, because you didn't have time to complete your statements when testifying before. Starting with Mr. Goldstein, do you have any specific observations of the warrant that you think are substandard? I'm not raising the issue of is it probable cause. That's ultimately a legal determination. But is there anything that you personally question in that warrant?
I think I have stated that there's a lot of surplusage. There's a lot of inflammatory material in the warrant that while it is terrible to read, just like it was terrible to listen to, has little to do with federal law enforcement and is certainly outside of the scope of the jurisdiction of the agency that was trying to get the warrant. I would point out
but let me stop you right there and just emphasize that. There is some rather graphic sexual testimony in the affidavit for the search warrant also.
Yes, there is.
But the offense for which the search warrant is being drafted is a firearms offense.
No question, and the ATF wouldn't have any jurisdiction to enforce the child sexual laws or pornography laws or deviant sexual activity laws of the state of Texas.
Well, you know, Mr. John said that if he arrested David Koresh, he was going to take DNA samples for some reason. Do you know for what federal offense he was going to do that for?
As I understood Mr. Jan's testimony, he said he was going to turn that over to state authorities, but that's what I heard.
Do you know if the state authorities asked for his assistance?
I do not.
There's
a nice deputy sheriff sitting next to me, but I haven't asked him.
All right. Let's go back to the warrant then. That's something you've read. Would you have some other specific examples with respect to use of informants, currentness of the information? I'll let either of you pick up wherever you wish on that. I just want to stress, I'm not trying to make a legal determination if probable cause still exists. I'm trying to get at was due care shown professionally in the drafting of this document.
Well, let me respond to that, if I may, Congressman. The fact is, officers who draw these applications tend to put in more information oftentimes than they necessarily need to, simply because they want to make sure that they cover all the bases. And there isn't any doubt that there is some irrelevant, prejudicial material in this application. But I think that it's common for officers to put that in the hopes that they don't inadvertently leave something out that they should have put in. Better to have too much than not enough.
How could sexual information, possibly if left out, have anything to do with a firearms charge?
It could.
Okay,
it's irrelevant.
Even some of the firearms information. For example, there's a quote that's referred to at least once, I think twice, of a child who had been living in the compound who said, "I hope to grow up because then I can practice with long guns like adults." Do either of you know of a federal offense in practicing with long guns by adults?
It's not just that it's irrelevant. It's inflammatory. It wasn't mistakenly put in there. Someone intentionally put that in there in the hopes that that would move a judge, the person that issues the warrant. The problem we all have is that the state of the law right now is that a judge will take, even if you had an outright lie, that you could prove that they had perjured themselves on the affidavit. The judge would simply excise that out, and you'd redact it, is what it's redaction, and that's the problem that defense lawyers out there and citizens who want to enforce these rights, which are the way that we actually protect ourselves from unlawful government abuse.
All right, let me point out the affidavit did mention, since it went into child abuse, that a child caseworker from the state of Texas Human Services Department went out to the compound. That person was allowed in the compound, wasn't restrained or shot in any way. Was that your understanding of the affidavit?
That is mine, and I would question both the resort to this kind of amassed military-like force when it does appear that there were a number of other opportunities, but this is hindsight and second guess.
Well, we have two things to start off. We have the fact that a Texas government official went out there and returned unmolested,
yes.
And we have at least a telephone invitation directly to alcohol, tobacco, and firearms to go out.
And it does appear that David Koresh had been out during that period of time and perhaps could have been apprehended without this, although that doesn't relate to the search of the premises.
Right. Speaking further on that, was there anything in this affidavit for the search warrant that indicated that exigent circumstances existed so that there had to be a no-knock entry? Did either of you see that?
No, but I can tell you this much. Before, interesting enough, Justice Thomas's unanimous opinion in Wilson versus Arkansas, you probably couldn't have found a defense lawyer out there that would have thought that the knock and announce provisions of the Fourth Amendment had any teeth in them. Quite frankly, there is nothing in there that would...
Did you see them even try to argue exigent circumstances in this affidavit?
Other than the argument that weaponry always presents some danger,
right.
There is nothing either addressed specifically to exigent circumstances, right. Nor is there a request for authorization to enter without knocking and announcing.
Just to conclude then, whenever there's firearms, there's potential danger, right, Mr. Goldstein, in a search?
No question.
All right, but in every other search, or most other searches, there's not dozens, if not 100, militarily trained ATF agents staging the raid either, right?
No question. It does appear that they did not do much in the way of availing themselves of less intrusive opportunities, and it looks like they spent all of their time amassing military-type equipment to engage in this raid, and perhaps even lied to state and federal officers and officials to obtain that equipment.
Thank you. No further questions, Mr. Chairman.
Thank you very much, Mr. Schiff. Mr. Schumer, you're recognized for 15 minutes.
Thank you, and I didn't intend to get off on this. Mr. Goldstein, what military-type equipment were used in the raid we're talking about? I don't know of a single instance.
The helicopters and other aircraft that would not normally be assigned to the police department, I would suggest that they are not military in the sense that they are unique to military. Here's what concerns me, and I'm not...
Our police, the NYPD, I don't know, out in Texas, all have helicopters.
They don't borrow them from the National Guard and
what does that have to do with it?
Well, because it goes to what we're talking, the callousness or the concerns I think many of us have to irregularity.
Yeah. Other than helicopters, was there any other military equipment used?
If you're suggesting that...
I'm just asking a yes or no question, Counselor.
Yes, I think that we don't need...
What was it?
Okay. I think the military-style attire...
You said lots of military-style attire.
Yes, okay. I think that I have a concern...
I finished this line of questioning. That's fine. Military-style attire.
I think the ninja mask, the black...
Do you know, is that standard ATF procedure?
I think it is becoming more and more standard in not only ATF, but law enforcement, even down to our local law enforcement. It's one of the things that I think defense lawyers are concerned about.
I'm not interested in your general views on what type of attire police and ATF ought to wear.
I think every law enforcement agency
Mr. Goldstein,
is now using.
That's enough. I have a series of questions here. You hadn't read the affidavit, and yet you were commenting on what happened there and led people to a conclusion that was all sorts of military types of things, and now we find out it's the typical ATF uniforms and a helicopter.
I don't think ninja...
My question is now to Mr. Barber. And what I'd like to establish here with you, Lieutenant Barber, and is that the ATF just didn't pick this place out of the clear blue. And first, let me just introduce you to the panel, that you are a member of the McLennan County Sheriff's Office during this time. Is that correct?
Yes, sir, that's correct.
Okay. When did you first become aware of the problems at the Branch Davidian compound?
The first notification I had nothing to...
If you can just pull the microphone closer. Thank you.
The first notification that our department got involved with actually came through the Immigration Naturalization Service.
When was that?
1990. And this had to do with the possibility of illegal aliens being out there, having overstayed their visas, etc.
Was there any knowledge about the 1987 shootout involving George Roden with your department?
Oh, yes. Okay. I was one of the arresting officers that took Vernon and his people into custody that day.
I see. And just in a thumbnail sketch, tell us what happened at that shootout as best you know.
I was the third vehicle to arrive, and at that time they had everyone in custody, and I was a weapons officer for our department. I made the weapons safe, cleared them, and the people were transported downtown. Right. And then I conducted an inventory of the weapons and all the ammunition that they had.
Right, and Koresh in that was charged with serious crimes, I believe including attempted murder?
Yes, sir, I believe so.
And ended in a hung jury?
Yes, sir. Okay. In his case, an acquittal on the others.
Correct. Okay, now after that time, did you receive complaints about activities at the Branch Davidian compound? In particular, did you receive complaints about automatic weapons?
Yes, sir. There were some people that lived close by said that they thought that they had heard automatic weapons fire there and wanted us to check on it. And I said, well, we can't post someone out there.
And these were neighbors complaining, hearing automatic weapon fire. Incidentally, we had asked, and in general the process has been fair, but we had asked that that gentleman be a witness, and we're not allowed that witness. Why, I'm not sure. The one who actually heard the automatic weapons fire, because he was a neighbor of Mr. Koresh. Okay, how about did a UPS agent talk to you about other things that were delivered to the compound? Could you tell us a little about that?
First of all, he talked to our chief deputy, Captain Dan Weinberg, concerning the grenades that has been mentioned quite a bit.
What was this with grenades?
Seems like a box of Mark II type pineapple grenades, if you will. The box had broken open somewhere in shipment with UPS, and that was reported to the captain. And he asked me if I had any knowledge of it. I said no. He said, well, you're also our bomb technician. I want you to work with UPS on this and just see what they're doing with them, if you can find out.
So UPS came to you and said, we've seen this, tell us if there's a problem.
Yes, sir. They came to the Sheriff's Department.
Were you also aware of not only shipments of these grenade cases, which we've heard the only possible use is for paperweights from the other side, although I have never seen one used as a paperweight in my limited experience, and hear about shipments of materials that might be used in those grenades to make them explosive?
Yes, sir.
Could you tell us a little about that?
One of the shipments consisted of aluminum powder.
Aluminum powder, often used in grenades.
Well, no, sir, not necessarily. It had to be mixed with other compounds.
Magnesium?
And magnesium and potassium nitrate.
Right. Okay. Let me ask you this. Why did you were the one, I presume, who called ATF and asked them to get involved. Is that correct?
The captain called first, and then I was put over as liaison with ATF.
Okay. So the captain of the McLennan County Sheriff's Department called ATF.
Yes, sir.
ATF, just to underscore, did not come in on their own. They were called by local law enforcement.
They were called in and asked to come in.
Right. Do you often call ATF on matters in your county?
When we determined the extent of the shipments that were coming in from all over the United States, that was beyond our capabilities.
Did you regard this as unusual and fairly serious, and is that why you called ATF?
Apprehensive.
You were apprehensive. And let me ask you this question, sir. Were the people in Waco worried about the compound? What was the general talk in the community?
At that time, there was none. Not that I'm aware of. I don't live too terribly far from the compound. And the people out there just said, well, you know, the people are a little bit different, but that was it.
Right. So what brought your apprehension were the shipments of various weapons, grenades, components, and things like that.
In conjunction with the prior occurrence in 1987.
Right. And again, it was the local government, not the federal government, that called ATF to the problem. ATF did not originate that.
That's correct.
Okay, thank you very much, Mr. Barber. We appreciate your coming a long way out here. My next bunch of questions now is to Mr. Deschamps. Am I pronouncing your name right?
Pronounce it Deschamps.
Deschamps.
Well, don't pronounce the
You're from
the P.
Missoula, Montana.
Yes.
I'm from Brooklyn,
Close
New York.
enough.
I apologize for the discrepancy in pronunciation. But you are the president of the National District Attorneys Association, as well as the DA from Missoula County, Montana. Is that
that's correct?
Okay. As a district attorney from Missoula County, I presume you've prepared or reviewed a large number of warrant applications.
Yes, and thinking about this, I think I've prepared probably 5,000 arrest warrants and a couple thousand search warrants.
Okay. And have you reviewed the search and arrest warrants as well as the accompanying affidavits in this situation?
I have.
And let me ask you, based on your many years of experience, the 5,000 warrants that you have issued, do you believe there was the sufficient probable cause for the magistrate, in this case Magistrate Green, to have issued the warrants to search the Branch Davidian compound and
Absolutely.
to arrest David Koresh?
Absolutely.
Explain absolutely. This wasn't one of those little borderline cases, despite the huge amount of extraneous material and despite certain erroneous material, sloppy material, as Mr. Goldstein described it in relation to Mr. Schiff's questioning. Is that correct?
That's correct.
This was not a borderline.
Probable cause simply means enough evidence to persuade a neutral and detached magistrate that the items sought are probably there. And I think any reasonable person reading this would say, beyond any question, the items sought were probably there.
Right. Now, we heard Mr. Goldstein say that the standards are probably too loose or whatever else, and I'm sure there would be many more on my side who would generally agree with that than on the other side. But the law, the status of the law, would be quite clear that this would be that this would clearly be within the ambit of the law, this search warrant.
Yes.
No doubt about that.
No doubt at all in my mind.
Okay, Mr. Goldstein, I want to continue on this, but my third point here is that at the criminal trial of the Branch Davidians who survived, they had excellent attorneys, and they didn't even mention...
Some of the best.
Pardon?
Some of the best.
Some of the best. You're familiar with people like Jack Zimmerman, Dick DeGuerin, and Tim Evans.
I grew up with them, know them. Some of them are in the room as we speak.
Well, welcome wherever you are. And these are excellent attorneys.
First rate.
Okay. Now, I just want it clear for the record that at that trial, which would have been the logical place to challenge these warrants, that there was no such challenge.
Absolutely right.
I'm not asking you the question, Mr. Goldstein. You're the witness from the other side. I want to ask our witness, Mr.
Sure.
Although you've been pretty good for our side, I don't deny that. But in any case, Mr. I'm sorry, Deschamps?
Don't worry about it.
Okay. Yeah. What's his first? What? What's his first name? Robert. If I can call you Robert, you can call me Chuck.
That's fine.
Okay. Wouldn't you find it, if there was some colorable doubt and there were excellent attorneys involved in the case, wouldn't you find it strange that they would not bring this issue up at the initial trial?
I would find it strange. Generally speaking, they were going to throw everything but the kitchen sink in there, hoping that if there's even a chance, that they've got to raise it to preserve it for appeal.
Right. And so the fact that these excellent, outstanding attorneys, in the words of Mr. Goldstein, who has known some of them since he was a child, didn't bring this up, would probably be far more dispositive of what is a good search warrant than you would think the author of a book or an expert on religion or a non-lawyer. Would that be a pretty good guess?
I would say yes.
Okay. And finally, and we'll hear more about that later, but again, I just want to underscore to everybody, a huge issue is the warrants. Now, one final point, and that is that it is indisputable that some 48 illegal automatic machine guns, you may not call them, I noticed in the dialogue, Mr. Barr didn't want to refer to them as machine guns, although an automatic weapon can be, but let's just call them automatic weapons, and grenades were found there. So it actually proved, Robert, that the presumptions of Mr. Aguilera, that the probable cause that he sought proved to be true in retrospect. Is that right?
Absolutely.
Not way off the deep end for sure.
No.
Not just one weapon found, not just one hand grenade, but many, many weapons and many, many hand grenades.
That's true.
And let me just ask you this, that the elements of the case, not only all the various, I heard somebody, Mr. Revis, the learned attorney, talk about, well, the hacksaw analogy. But you also had a history of violence. You also had neighbors who had heard both rapid automatic weapons fire, including somebody who's a former Marine who knew what automatic weapons fire was. You had an apocalyptic theory, plus a huge amount of weapons that brought Lieutenant Barber and the McLennan Sheriff's Department to do the unusual step of calling in the ATF. All of that together seems a pretty good case.
I would think so.
In prospect, and in retrospect, 48 weapons, many hand grenades were found. So, would you take that case?
I certainly would, yes.
Yeah. I mean, it seems to me that this issue, there are some issues, and we'll get into some of those down the road, may be open to some dispute. But I think, and it seems pretty clear to me, that on the issue of the warrant, both in reality, 48 weapons, many hand grenades, both and in prospect, lots of various evidence, it seems pretty clear that nobody did anything wrong at all, let alone in a conspiratorial way to get somebody. Fair enough, Mr. Robert?
I think it's fair enough, and I guess in view of events of recent times, we had a couple 100 pounds of high explosives in there that I think couldn't hardly be ignored
in fact,
despite anything else.
I can think of situations where if the prosecuting authority, whether it be ATF, McLennan Sheriff, or anybody else, had all this evidence and didn't look for a warrant, there'd be outcries from everybody. So, final question to you, Robert, and that is it even if the warrant were illegally executed, even if ATF could have found a better way to do it, and we'll get into that on the next panel, because remember, folks, this is a search warrant. You don't, and just maybe, Robert, you could just corroborate this from your experience, when you want to search a place, you don't usually go serve somebody or arrest them off the premises, since you don't want the place to have destroyed the evidence. You don't, right? Isn't that correct? The proper procedure when you do a search warrant is to serve it at the place you're searching?
Absolutely. In fact, I think the law requires that you leave a copy at the place
Not when someone's jogging or getting ice cream or visiting another place. You serve the place.
That's right.
And the proper response of a citizen, no matter how angry at the federal government, no matter what religious theory they might ascribe to, no matter how sloppy the search warrant is what, Robert? Is it to accept the warrant?
Accept it and challenge it in court later.
And you agree with that, Mr. Goldstein, I presume?
I would agree, and I think there's a reason why good lawyers would not challenge this warrant.
Okay. And I would say it certainly is not the correct thing to do, is to either threaten or shoot at those who seek to serve that warrant. Is that correct?
That's correct. In fact, it's highly illegal to do that.
Thank you, Robert.
Thank you, Mr. Chairman. Your time is up, and now we enter our 5-minute period of questioning. On the right side over here, the first 5-minute questioner is Mr. Blute. You're recognized for 5 minutes.
Thank you very much, Mr. Chairman, and I want to thank all of the witnesses for their testimony. They've been here a long time, and we appreciate it. And I would like to get into something with Mr. Thibodeau, because I know it's our understanding that you can't be here later in the hearings to deal with the actual day of the raid.
After the 21st, I can be here anytime you need me.
Well, but if you're not going to be here Friday, is that correct?
Yeah, that's correct.
Okay. Well, since you can't be here Friday, I would like to get into the record if I could, because you're one of the witnesses who was actually there the day of the February raid. Were you not?
Yes.
You were there. Could you take some minutes in describing what happened that day, what you saw happen starting in the morning?
In the morning of that day, I was in the cafeteria area of the building. I'd eaten breakfast. And after breakfast, I took a walk down the hall. And I got down to the hall, and David Koresh was sitting there with Robert Rodriguez, who we know to be the undercover agent now. Robert Rodriguez was sitting there talking with Dave, and he had been over quite a bit, I would say, on 8 or 9 separate occasions. So I didn't really think too much about this. Now, the night before this, the day before this, the Waco Tribune-Herald had started to print the Sinful Messiah series, a 7-part series. So obviously there was concern over that. And, you know, David did kind of view that as the beginning of the end, but obviously we didn't know how soon this was going to take place. Just really quick, if I may say, David's hope was still that the music would go forward. He wanted to get his message out through the music. And he was hoping that if this were an undercover agent, he always gave the gentleman the benefit of the doubt, he would see where Koresh is coming from another side, from a scriptural side, and perhaps go to his superiors and try to talk to them about this other aspect.
Did you have some sense that this person was an undercover agent yourself?
Yes, I did.
You had heard that in the compound?
Well, not so much heard it. Well, Wayne Martin was really suspicious, and he checked him out. The thing that was kind of the giveaway for me, I mean, here are these guys, there's 4 or 5 of them living over in a 2-room apartment. You know, they have $40,000 automobiles, Serengeti sunglasses, Rolex watches. They're coming over claiming to be college students. You know, I guess the plot kind of thickens when they say that they're going to TSTC, which is a technical college. You know, you go for maintenance, things like that. And I asked Robert at one point, you know, just casually, because I spoke to Robert on a number of occasions. I said, you know, Robert, what classes are you taking? And he said, philosophy. And I basically thought that was pretty funny, you know. But anyway, Wayne Martin did, I guess he checked some license plates and found that they were registered to Dallas somewhere. It was Dallas or Houston, I'm not sure exactly. But the story just really didn't check out. And, you know, Wayne Martin was really paranoid over it. I remember him, like, being nervous.
So it was a common suspicion in the compound that Rodriguez was not what he said he was?
Yes.
From early on?
Yes.
Okay.
David's whole
Continue on that day.
Okay. David's whole attitude with that was, well, you know, even if he is working with the government, even if he's with the National Guard, it doesn't matter. You know, I have a truth here that is being presented, it's going to be presented, and hopefully this person will see something that the other people, from you know, not having the experience of one-on-one with David, you cannot see. So that was the hope. That day I saw them talking, I didn't think much of it, and I went back.
Let me just speed you up to the time of, where were you when the raid began?
I was in the cafeteria. I started to hear the helicopters coming from the back of the building. It was very faint. Koresh came down the stairs. My recollection is that Koresh was not armed. There were some people around Koresh. There was, I would say, quite a few, 5 or 6. And there was a lot of doors slamming throughout the building at this point. It just seemed like a lot of action was taking place at once. And David held his hand up. At this point, there were people coming in from the other area of the building. I wish I have a diagram, but they were coming in from where the dormitories were for the men. They came into the cafeteria. David held his hand up and he said, "Now, okay, they're coming, they're on their way."
This was after the helicopter noise was audible.
Yeah, we can hear the helicopter and it's getting louder and louder. He said,
when did you first see the helicopter? Did you see the helicopters?
I did not see the helicopters personally, but they were very loud, they were very clear.
And we've heard testimony, I have to finish here, but that the helicopters came a significant period of time before the raiding party. Is that your sense of what happened?
My sense of what happened from where I was is after David Koresh made that statement, he said, "Don't do anything stupid. We want to talk to these people. We want to work it out. That's what we're all about here at Mount Carmel." And I'll never forget those words because I was really scared. And when I heard that, you know, it was like, okay, David's going to try to talk to him. Maybe this can still be avoided. He went to the front door. Now, from where I was in the cafeteria, it sounded to me like the shots were emanating from the front, okay? Now, I talked to Rennis Abraham later and a couple of the other survivors. Rennis particularly, testimony was very strong. I said, you know, this is considerably after hours later, maybe even a couple days later. Time really was kind of like a tunnel vision type thing. But I talked to Rennis, and Rennis said, you know, I said, you know, Rennis, what did you think of all that firing just starting at the front door? And Rennis said, "It didn't." I said, "What do you mean?" He said, "I was outside, and I saw the helicopters coming in, and I saw fire coming from the helicopters into the tower area, and it initiated with the helicopters firing." I said,
didn't see that yourself?
No, I did not.
People there told you that on that day?
Yes, and I said, "Rennis, are you sure?" Because it didn't go with my experience. From what I heard, it sounded to me like the front door. And he said, "I am positive," which indicates to me that it was simultaneous, that you had the group at the front and the group at the back, and the only way that that could have occurred is if it all occurred together.
Well, Mr. Chairman, I think this is very important testimony. Mr. Thibodeau has a statement outlining what he thinks and what he saw happen on that day, which I think is very important, that I hope we can get into the record. Thank you.
Certainly, any written testimony Mr. Thibodeau would like to make will be admitted to the record without objection. Yes, Mr. Taylor.
Are we dealing with hearsay evidence here? And I'm not an attorney, but when someone is using second-hand testimony...
Well, parliamentary inquiry is taken. We, in court proceedings, you might be able to not have hearsay in it, but in congressional hearings, hearsay is admissible. There is nothing that prohibits that.
Mr. Chairman, to continue my inquiry, will the record clearly indicate that this is second-hand testimony?
Well, it obviously does. You just made
Thank you very much,
that
sir.
way. Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Mr. Goldstein, I want to get away from the particulars of this case for a second and go into some generalities and ask you to explain how the, in your written testimony, you go into the Fourth Amendment, and I'd like you to say for a minute or so how the exclusionary rule protects innocent people from police misconduct.
The exclusionary rule is a judicially crafted rule that, in effect, precludes from the introduction into evidence any items or evidence that was obtained by the police illegally. I think the general citizenry out there thinks that liberal courts are unleashing violent criminals on the citizenry to beat up on them. In actual fact, less than 1/2% of the citizens charged in this country ever benefit from a motion to suppress. But the theory is that by excluding illegally obtained evidence, evidence that law officers obtain in violation of the supreme law of the land, that will deter them from engaging in that illegal conduct because they won't want to go out and obtain evidence illegally if they know they can't use it. The importance is that while it only benefits 0.5% of those charged, and many of them may be innocent, everyone benefits from it because the general discouragement of illegal police activity protects you and me and the innocent citizens out there whose homes are not intruded upon. So it protects 100% of the innocent citizens and only benefits a small infinitesimal percentage of those who may in fact be guilty.
Now, if you have an allegation of police misconduct or illegal activity on the part of the police in obtaining evidence, prior to 1984, where in the Leon case, what part of the judicial proceeding would you argue the case that the evidence was illegally obtained?
It would be at a pretrial motion, Mr. Scott, through a motion to suppress. What's interesting is Mr. Taylor's point, hearsay evidence would be admissible at a suppression hearing. It wouldn't matter that there wasn't probable cause because, in fact, according to Leon, after 1984, the officers could...
Before 1984...
Prior to that time, you would be... In fact, instances like this, these kinds of issues would be viable prior to 1984.
Now, after Leon and the good faith exception, how has your ability to challenge police misconduct been compromised?
Well, that's what I wanted to answer to Mr. Schumer. No good defense lawyer with his head screwed on right is going to file a motion to suppress where there's a warrant simply because the officers are entitled to rely upon the warrant even if it's totally lacking in probable cause. And even if there's a lie, because in order to meet the standard of Franks versus Delaware, which is a hard standard to prove, you're going to have to prove, in fact, by sworn testimony that there's a lie before you can even call a witness, before you'll get a hearing, before you can ask a single question. So what I'm going to ask is, nobody wants to hear this apparently, is if we're going to have anything out of this hearing that's going to regulate and control illegal police practices, what we need to do is put some teeth back in the Fourth Amendment and give the citizenry some means of protecting themselves.
Let me get to the particulars of this case, Robert. If you could show, now I think in this case there's plenty of evidence to support the search. You've got the USPS testimony, you've got statements from arms dealers of what had gone in, you've got statements from neighbors, you've got plenty there. But if you could show that this warrant had been obtained by irrelevant, inflammatory, and unreliable evidence, what could a innocent person, if we're going to discourage searches of innocent people, how could any of the defendants in this case have brought up a challenge to the evidence?
Frankly, I'm not sure that they... I'm not sure that they... Well, they could have brought up a motion to suppress. They certainly could have asked for a Franks hearing to show that there was, if there are lies in there, and I don't see any, but suppose there were, that would be their one remedy they have. I have to disagree with Mr. Goldstein. It isn't an automatic silver platter that you get a judicially issued warrant. If the officer himself knows, there's plenty of recent case law on this point.
If the
officer knows that it's based on
my time is almost up. If the searching officer didn't know about all the irregularities, how would they be able to bring this up in a hearing?
Through a Franks hearing, to show that there were inappropriate, illegal lies, falsehoods that led to the probable cause.
Which, in order to get that, you're going to have to be able to demonstrate that by sworn affidavit. How do you get that if you haven't been able to call or ask a questionable witness?
Thank you, Mr. Chairman.
Thank you. Mr. Bryant for 5 minutes.
Get the same extra minute that
Mr. Chairman, before my 5 minutes starts, I would ask unanimous consent to submit an opening statement for the record.
It is granted without objection.
Thank you. As a former United States attorney, I had a very positive experience with law enforcement in my area with ATF and the FBI. But I have some very grave concerns about the environment that existed in Waco in February of 1993 that apparently compelled this raid to occur that day. And as such, I wanted to ask just a few questions and maybe bounce around a little bit and tie up some loose ends. Mr. Thibodeau, are you familiar with a Mark Bro?
Yes.
Does Mr. Bro have any physical impairment?
Yes, he has a significant sight impairment. From my understanding, he's legally blind.
Okay. I bring up Mr. Breaux because as a part of the basis for this search warrant, the agent affirms under oath that he interviewed Mr. Breaux in Los Angeles and that Mr. Breaux indicated he actually shot weapons and performed guard duty with a loaded weapon.
He also used to tell stories about swimming for sharks and, you know, he used to tell some whoppers, let me put it that way, according to Steve Schneider and some of the other people that I used to speak to about Mr. Breaux's experience in the past. You know, nothing bad or, you know, just he was a kind of a storyteller, yeah. Was the impression I had.
Thank you. Again, as a former prosecutor, I don't mean to concede, and I certainly don't, that Mr. Koresh's actions were proper in his reaction to the service of this warrant. I think he had an obligation to respond lawfully and challenge it in the courts. I disagree totally with that action. But as I said before, I'm concerned about other issues that from the other side. Mr. McMahon, Mr. Koresh did go to gun shows and deal in firearms and grenades and paperweights and so forth. Is that correct?
I never seen any hand grenades, but I seen upper receivers, knives, accessories, magazines. I mean, he had, you know, he went to gun shows and he advertised even. I mean, here's one of his business cards. I mean, I'm sure y'all have seen all these.
I'd like to put that in the record if I could.
Sure.
But when I say hand grenades, I mean empty shells that are used on vests. And are you familiar with that practice of putting them on vests or using them as paperweights?
Yes, sir, I am. That's I'm really surprised that Mr. Schumer didn't see that before. I mean, everybody's seen the pull pin complaint department, you know, pin number 1. But that is a common practice at gun shows, yes, sir.
Deputy Barber, I understand you're retired now from the county sheriff's office.
Yes, sir, that's correct.
And you were familiar with the Koresh people?
To a degree, yes.
And were you consulted by the ATF before this raid occurred on February 28, 1993?
Yes, I was.
Were you familiar with the fact that there were, as a part of the Davidians out there, what I understand to be a number of elderly people and a number of, obviously we know at least 20 children? Did you know they were out there?
Yes, I did.
Did you make this fact known to the ATF, or did they already know that?
I feel they already knew that.
Let me ask you if I could. Are you familiar at all with, were you familiar with the fact that Mr. Koresh was dealing in guns at gun shows?
I had not seen him at a gun show there in Waco. I had seen Paul Fata.
Is it normally the practice of ATF to also monitor and attend these various gun shows as just as a practice?
I can't tell you what their practices are.
Mr. Goldstein, let me follow up. I'd understood before that you had expressed an opinion that because of what you perceive as the misapplication of law to the facts of this case and the staleness, and I don't think our fellow prosecutor talked about the staleness of this information, the age of it, and because of perhaps the lack of credibility on some of these witnesses who talked to the agent, that you had some grave concerns about the validity of that search warrant.
It is true, Mr. Bryan. I am concerned any time there's that kind of lapse of time between the date of the information and the date that the warrant is actually sought to be executed, because I think there's always a danger there that even if it existed, it won't be there when they go. I was concerned...
Could I cut you off just a minute?
Sure.
And ask one quick question back to Mr. Barber? Do you know what occurred in February that compelled the ATF to go in that day on February the 28th, even when the element of surprise was lost? Why they had to go in at that time?
No, sir, I do not. I do know that the raid, as it's being referred to, was scheduled for the following Monday. I was aware of that.
And they moved it forward a week?
And they moved it forward one day.
Okay, right, Sunday. Thank you.
According to my list, Ms. Lofgren, you're next up for 5 minutes.
Thank you, Mr. Chairman. First, I'd like to thank the attorney for being here today and for telling her how proud I am of her to be here and speak up. And it's not easy for anybody, even a grown-up, to come and testify, and I think you're a pretty special young lady, and you're doing something important for your country. In reading and listening to you, you note that there were some other girls. Your written statement mentions little Esther that your mother had mentioned, and also Rachel. Were you aware that other little girls were being molested by Mr. Koresh?
Yeah.
Did you know about that? And you probably don't know about this, although maybe you do, and I'll ask a question. There was a Dr. Perry, who I think we'll get into that later in the panel, who in March contacted the FBI and talked about some of the other little girls who had been involved in, had been abused by Mr. Koresh, and they reported to him information about wirings and explosions and things of that nature. Did you ever hear about guns or weapons or explosions, or did you know anything about that?
Yeah, guns. I never saw any explosions. I remember one time I was in David's room above the kitchen. This was before they rebuilt the whole compound, but it was above the kitchen. And he pulled out this gun that had to have been, I don't know, it was huge. It was huge. I mean, I of course was like 8, so it probably was a little bit bigger, but it was huge. Just the bullets itself had to have been like this big, with nails that came like this on each side of the bullet to keep it together, just like, yeah, on a chain, like rows and rows of them, and they were just coiled up in his drawers. Yeah, like Rambo. It was incredible. It was just, and he was proud of it. It was his toy. It was his new toy that he had just gotten, and he was showing it off.
Now, in February, you and your dad went and spoke to the federal agents, and what did you tell them? Do you remember what you said to them? Or maybe I misunderstood when you answered Karen Thurman earlier.
Which part?
Did you, in February, go and speak to the federal agents, either the FBI or ATF? Do you remember what you talked to about with
About
them?
being molested. That's about what I remember. About the children there, who the children's father was. Just that. It was mostly about the children.
Now, this is, the deputy sheriff said the first call that they got had to do with the Immigration Service. Do you know anything about marriages or that could have been arranged by Mr. Koresh to avoid the immigration law?
They were arranged.
Can you tell us anything, which
Names?
marriages? Well, I don't know if we need names, but can you tell us what you knew and how you knew it?
Like I said before, I listened and remembered. There were, I could name right now at least 5 marriages that were arranged so that people could stay in the country.
All right.
At least 5.
Now, you, thank God we're not in the compound on the day of the raid, but you mentioned in your statement that you were on the phone frequently with your mom, and she was pointing out that you would lose your place to Rachel and that sort of thing. The impression that you got from talking to your mother and what you saw when you were available to see things, how does that jibe with the statement that Mr. Thibodeau made that gives a more serene picture that things would be settled peaceably? What was your impression of what was going to happen, and why did you think, as you stated earlier, that it would end with no one coming out and with suicides?
Because there was always some sort of violence, not inside the compound, but the whole time you were there, you were prepared to die, the whole time. One time my mom picked me up from the library. I was probably 9, and she said, "Are you ready to go?" And I said, "Where?" And she said, "To Israel, we're going to Jerusalem." And I said, "Okay." I wasn't going to leave her. But she said, "Okay, I just wanted to see if you were ready to go." And you were always ready for something. Always had the little scared something inside of you.
Finally, the first panel of witnesses talked about this whole issue as a matter of religious freedom. Were you ever given a religious rationale for the molestation that was ongoing with the little girls in the complex? Was there a reason given?
The only thing I remember was that he would say that King David from the Bible would sleep with young virgins to keep him warm, and something about Psalms 45, I think it was, something in there justified all of the molestation. I don't know, there could have been something else he found that justified it, but that was what I remember.
Thank you, Kiri, and thank you for your bravery.
Thank you. Thank you. Your time is up, Ms. Lofgren. I note from the minorities list that we had incorrectly let you have that time at that moment. Ms. Slaughter was supposed to get it, but I'm told we're going to correct that because Mr. Schumer is going to yield to Ms. Slaughter in a minute. But where we are at the stage of these proceedings is the time where we have the ranking members and the chairman have their opportunity to question or to yield to somebody for asking questions. And I'm going to take my 5 minutes at this point in time, and then I will yield to Mr. Schumer, who I guess will yield to Ms. Slaughter. I want to ask Mr. Thibodeau a question. You were there the day of the raid, and you were there all the way through the fire at the very end, were you not?
Yes, sir.
Can you tell us anything about how the fire began?
Here's a couple, this is how I look at it, and I put this in the report, okay. At around 12 o'clock, after being CS gassed the entire day, after having a black leather jacket on and seeing little white spots all over it that were absorbed into the jacket, finally, I heard someone yell from the upstairs. Can I prerequisite this for something that happened at 10:30 that I think is very important? At 10:30 that day, I was listening to the radio, and a news report came on. And the news report was saying the Branch Davidian compound in Waco, Texas is being assaulted, and Janet Reno has okayed a tear gas plan. Due to the credit of the FBI, they have not fired back when the Davidians on the inside had returned 80 to 200 gunshots against the CEVs. All I want to say is I was in a fairly central, I was in the chapel area, and I had heard shots fired accidentally throughout the course of the 51 days, and you could hear them throughout the building. And I did not hear any shots that morning fired. And I was overwhelmed with joy at this point after being gassed that my friends were not firing at these tanks, because obviously the FBI were saying if you fire at us, we are going to fire back, and not just CS canisters or ferret rounds. So I remember being overwhelmed that my friends were not stupid enough to fire at a tank, because a .223 round wasn't going to penetrate it anyway.
Well, what about the fire?
Okay. What I was saying is, to me, that appeared like a setup for a massacre, and it greatly disturbed me. At that point, I'd lost all hope. At 12 o'clock, someone yelled from the upstairs that there was a fire. The front, I could not get to the front because of what the tanks had come in, the stairwell that was closest to the front, so I went to the stairwell in the back. At this point, and I have some pictures available, the back of the gym was thoroughly destroyed. The tank went in and actually leveled the back of the gym area, if you're facing the gym, the right half of it. So I went halfway up the stairwell, and I could see the door, but I couldn't get to it because there was this huge beam in front of me and debris everywhere. However, David Koresh's room was on this side. I could put my elbow up on the floor of the second story. I climbed up. It took me quite some time to climb over the debris without getting cut. I went to his room. And then to an adjacent room, which was an office space. I get in that room, and there was a catwalk that was leading over the rafters of the church area, say from here to here, which is the front of the building. This is the front of the building. I walked to the front, and we were still in the process of building Mount Carmel. I got to a blanket. I opened the blanket up. A big gust of smoke came at me. When that dissipated, I went to stick my head inside there because I'm thinking the kids. I'm thinking Serenity C. Jones. I was thinking of Isaiah and Joseph, some of these kids that I've come to know and love, and getting them into the bus, an underground bus that was buried, because I was under the impression that that was the plan. I get up there. I open it. After the smoke dissipates, I go to stick my head in, and a wall of flame shoots down the hallway in front of my face down to the other end of the building. It was the loudest sound I've ever heard in my life. I'm a drummer. And it was incredibly loud. I could not hear anything else other than this flame.
Well, do you know how the fire started? Did anybody tell you, or do you know personally how the fire started?
No.
Was there any plan for the fire to be started that you heard?
No.
You know, we've heard tapes. All right. I want to go to you very quickly, Mr. Barber. Box of grenades that came from UPS, those were dud grenades, not live armed ones. Is that not correct?
Yes, sir, they were practice grenades.
Methamphetamine lab, do you ever know anything about a methamphetamine lab out at the compound?
There was a rumor of one prior to.
3 or 4 years prior to this, though,
Yes,
right?
this would have been back in probably 87.
But not current with the raid or current with the time Argulia or the ATF were going after these folks, right?
No.
All right, I want to ask a question to Mr. McMahon very briefly. In the book that Mr. Revis has written, he talks about your having a relationship with David Koresh to sell guns or through the compound to have a refitting of guns or putting together a certain type of weapons, that y'all have made an arrangement or an accommodation to sell them weapons over time. Do you know anything about that? Do you know what I'm talking about?
I think what he's referring to is there was this deal that we did. I bought the frames and he bought the upper receivers, and David put them together, and then I turned around and sold them. There was a total of 5 or 6 guns that I had sold that way.
Was this an ongoing arrangement, or was this something that just happened once and it didn't happen again?
It had just started when ATF came and did a compliance check, and I explained to them exactly what was going on. And they said that they had a problem with the excise tax. They said the excise tax had to be paid. And I'm going, I don't know anything about this excise tax. And after they left, we stopped doing it. We didn't do it anymore. I only sold us 5 or 6 guns, and that was the only time.
All right. Well, I thank you for those comments. Now I'm going to turn to Mr. Schumer. I've had my 5 minutes. I gather you're going to yield yours to Ms. Slaughter, but you get the privilege of doing that.
It's my pleasure to yield my 5 minutes to my friend, colleague, and able legislator, Ms. Slaughter of upstate New York.
You're recognized for 5 minutes.
Thank you very much. Mr. Thibodeau, are you married?
No.
Are you involved in a personal relationship, or have you been with Mr. Koresh's sister-in-law, Michelle?
Personal relationship that you're referring to is I had a large hand in taking care of Serenity C. Jones and her other twin daughters.
You live together?
No, we did not live together. We lived in the same building. So, yeah, in a sense, we lived together.
Is she the same Michelle Jones that Mr. Koresh referred to as his favorite wife, and had she been with him since she was 12 years old?
I have no knowledge of him referring to Michelle as his favorite wife and being since 12 years old.
She has, I believe, 3 children.
Yes.
How old are they?
3, and the other ones were twins, approximately 1.
Are they children of Mr. Koresh?
Yes.
And he admitted that?
Yes.
All right. Mr. Thibodeau, did you live at Mount Carmel?
Yes, I did.
And you were there then on the day, February 28th?
Yes.
And the testimony that we have indicates that there was a 45-minute notice that the ATF was coming. Is that correct?
Well, I believe that some people had a majority of prior notice, that there was some kind of prior notice, but not everybody did. My example of that would be Winston Blake, who was found with a piece of French toast in his hand laying on the ground.
Well, tell me, where did this prior notice come from?
Prior notice, I believe that it came from David Jones, who was the mailman.
David Jones, the mailman, told you that the ATF was coming in 45 minutes to serve a search warrant.
He did not tell me personally. Apparently, he went up to the front, the foyer area, where David was with a group of people, and told Koresh.
And you were there with Mr. Koresh?
No, I was in the back. I was in the cafeteria area.
You were nowhere around Mr. Koresh at the time he was around the front door?
I was not.
Was Mr. Jones a member of the Branch Davidians?
Mm-hmm. Well, see, again, I always consider myself a student of the 7 Seals. Branch Davidian is something that I really heard in February 28th when the ATF raided, so.
But Mr. Jones was a member of your group?
Yes.
Let me put it that way. Was that known to authorities that Mr. Jones was a member of your group?
I would think that it would be. I mean, he's the mailman in the community, and he spends a lot of time out there. He lived out there for some time. He did have a private residence.
Do you have any idea where Mr. Jones got his information that the ATF was coming to serve a search warrant?
From what I have read and been told, it was from a news media truck that was at the other end of the property, down at the end of the Doubly Ranch Road, I believe it to be.
A news media truck told Mr. Jones that the ATF was on its way. That's
well, the story that I heard, and you know, this really got. David didn't really talk too much about it to me personally, but the story that I got from the news media, and I will say that I take everything I hear from the media with a grain of salt, that there was a news media truck down there, and
I have another question I want to ask you before my time comes up. You knew Cyrus?
I'm sorry?
Mr. Koresh's son, Cyrus?
Yes, I knew Cyrus.
I believe was the son of his legitimate wife, Rachel?
Yes, ma'am.
Were you there when, at the age of 3, Cyrus was forced to sleep on the kitchen floor night after night and without any food until he was too weak to eat?
No, I had not heard anything about that, and I really doubt the validity of that story.
And would you know anything about Cyrus at that point being taken to a garage in Pomona, I believe, and kept in a garage overnight? There are witnesses who say they took him there. He was told by his father that there were huge rats in this building, and he was made to stay there alone, terrified and scared.
Okay, of course, what you're referring to is the film that came out. I called the...
No, I haven't seen any film at all.
Well, there was a film.
These were testimonies from witnesses who, including a man who himself took young Cyrus at the age of 3 out to spend overnight in a garage with rats.
I came onto the scene in 1991. I believe these things, if they happened at all, happened prior to me coming onto the scene. But I have never heard any talk about this occurring. And when I saw this ATF propaganda film, ma'am,
is it your testimony, is it your testimony, Mr. Thibodeau, that he did not spank children as young as 8 months until their bottoms bled?
No, he did not till the bottoms bled. He did spank his children when they were disobedient. But basically,
8 months old,
the
Mr.
mothers did.
Thibodeau?
I don't know about 8-month-old children being spanked.
Mothers have testified to that, as you know. Carrie, do you know anything about that? Were babies spanked at that compound? Little babies? Did you know Cyrus?
Yep.
Is what I said about Cyrus, is that true, to the best of your recollection?
I don't know.
How small were the babies when they were spanked, and did you ever see any of those spankings?
8 months old.
And these babies were spanked with what?
A wooden paddle.
Called?
Helper.
Helper. And what reason would drive Mr. Koresh to spank an 8-month-old child?
Robin Buns' son countless amounts of times because Wisdom didn't like him, and Wisdom would run away, and he would call him back over and spank him, and then Wisdom would run away again, and he would call him over and spank him again, and then he would tell Robin to go spank him, and he would sit Wisdom on his lap, and Wisdom would be sniffling and crying, and then he'd run away again and get spanked.
Have you ever known of any occasion where Mr. Koresh kept a child from having food?
Sure, you can answer that question, Ms. Slaughter, but your time is up.
It is, but if you'd answer that for me, do you know if he punished by denying food for more than 1 day or several days at a time?
I don't know about that, no.
Thank you very much.
Mr. Zelloff, for 5 minutes.
Carrie, thank you for being here. I know it's been a long and difficult day. Just on the record, you were invited as the Democratic minority witness, and it was you asked to be here by subpoena. Is that correct?
Yeah.
And you needed the subpoena because it was needed so that your father could be with you? Very much. Mr. Goldstein, is it possible, or on probable cause, is it possible that it becomes stale? And is it stale if it's 6 or 7 months old? And would a warrant be valid if probable cause was stale?
There are very few cases that actually deal with the issue of staleness. But there is a lot of rhetoric, a lot of dicta in cases that suggest that staleness is certainly relevant to probable cause, and it goes to whether or not you would have a reasonable belief that whatever you have that causes you to believe items of evidence will be located at a particular situs will still be there when you attempt to obtain the warrant and execute it.
Thank you. The warrant authorized the search of the entire premises of the 77-acre compound. All buildings were included in the scope of the search. This included all personal belongings of some 90 men, women, and children, besides the person named in the search warrant. Given the crimes alleged to have occurred, is the warrant so overbroad as to be unconstitutional?
There are always those concerns, and I think this is if there's something healthy that comes out of these hearings, it would be that an evaluation of what we expect goes on during motions to suppress in criminal trials is not, in fact, what does. The truth of the matter is that a warrant should be, the Fourth Amendment talks about a particular item in a particularized place. One would want particularity. It would keep them, for example, where people were living, for example, in a college dormitory, from searching the entire building because of probable cause to believe one errant student had violated the law. On the other hand, I can tell you this from common experience, and I think you could talk to prosecutors and defense lawyers who would agree with me, the idea that we will prevail on motions to suppress because the probable cause is stale, or because the warrant is too broad because it allows the search of an entire building where the distinction between rooms and residences is difficult to pinpoint, is foolhardy. Quite frankly, that's one of the reasons why none of these good lawyers raised the issue. It's simply, in practice, we don't have any teeth in terms of being able to enforce these kinds of restrictions that I think, as your question points out, are needed. We need to restrict law enforcement in terms of time. We need to restrict them in terms of place. That's not asking too much, and they're able to enforce the laws, I think, adequately with those kinds of restrictions.
Thank you, Mr. Goldstein. Mr. Thibodeau, tell us about finding Winston Blake dead.
When the raid initially occurred and the shooting started, I got down on the ground. I went into the dorm area I had mentioned earlier. Wish I had a diagram to show you. But I went down the hallway of the dorm to the end. Actually, the first room I went into was the weight room, and I waited there for, I would say, between 5 and 10 minutes. Time is pretty irrelevant when you're being shot at. Then Jimmy Riddle and Oliver Garfus Jr. ran down the hall in front of me. They went to the underground bus area. They opened up the door, and they went down into it, and that's when I followed suit behind them. I got downstairs, and Oliver Garfus Jr., myself, and Jimmy Riddle were down there. Jimmy went down the hallway into the tornado shelter that was being built. He started to walk around in the mud, and the agents could hear him from upstairs, and they were yelling obscenities at him, telling him to come out, screaming at the top of their lungs, obscenities. I think that Jimmy wanted to make sure that they weren't going to come in and take us out that way. Anyway, to make a long story short, after a period of, I would say, 20, 30 minutes, we went back upstairs just as the ceasefire was being established. Jimmy Riddle and Oliver Garfus Jr. ran up the hallway. I was crawling still because there was some sporadic fire. I came to the first room that was to my left, and water was pouring out of the bottom of this room. And again, there was no door on there. There was a blanket on there. I opened up the blanket, and I looked in, and it was the area of the building where there's 3 water tanks on the outside. The middle water tank had been punctured a number of times, as well as the glass. The first thing I focused on was the glass that was shot out. My eyes were still adjusting from being in a dark place. I noticed the water pouring out of the bullet holes onto the floor. I followed one of the streams down, and there was a body there. I couldn't tell who it was at first. After a period of time, my eyes focused on the body, and I could see that it was a large lump. I made it out to be Winston Blake. I remember he had a red jacket on, and it was Winston. And the water was pouring down onto him, and there was a pile of blood by his head. He was not moving. I pretty much knew that Winston was dead and was not going to move. I shut the curtain. I went up the hallway trying to hold my breakfast in that morning.
Last question, Mr. Thibodeau. On this, this is a hand grenade. This happens to be a paperweight. Is this similar to some of the things that you may have seen inside this little paperweight here, this hand grenade?
Yeah, it looks similar.
Is it possible that this hand grenade could be a paperweight?
Yeah, it is possible.
Okay.
I say that in the extent that if you put a sign on there that says complaint department pull pin, then obviously it's a paperweight. It depends on what is inside the hand grenade that makes it active or not.
This paperweight
it's also possible it could have been active.
Is not a hand grenade or used for the intended purpose of a hand grenade.
No, it's possible either way, sir.
That this could be a paperweight that is not dangerous. It's just used to hold papers down?
Yes.
Mr. Zell, your time is up.
Thank you very much.
Ms. Thurman.
Thank you, Mr. Chairman.
minutes.
At this time, I would like to yield my time to the distinguished gentleman from Mississippi, Mr. Taylor.
Mr. Taylor, you're recognized for 5 minutes. Mr. Jewell, like some other members of this body, I was a bit disturbed by some of the graphic things your daughter had to say. But having said that, I think it is also very fair that you be given an opportunity to tell this body about your experiences in going to court in Michigan to prevent your daughter from being held in custody by David Koresh, the events that, again, why don't you tell this committee some of the things that you know that were going on that the Michigan court agreed with when they decided to keep your daughter from ever being in the presence of David Koresh?
I wasn't expecting to speak today, so this catches me a bit off guard.
I don't believe that he's been sworn in, but I'd be very glad to do that, Mr. Taylor. I won't do it on your time. If you'd don't mind, if you'd raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Then the record will reflect the answer was affirmative. You may be seated. Mr. Taylor, you still have 4 3/4 minutes or something like that.
In the process...
Parliamentary inquiry, please state it, Mr. Senator.
Will other people be added without notice, and can other people bring in witnesses?
Normally that would not be the case, but I believe under these circumstances with the father of the young woman here, it's appropriate.
I understand it's extraordinary. I'd just like to know the...
No, normally we would not. We've got a schedule, we print them, we publish them. It's a good inquiry, but you're correct.
Mr. Chairman,
Yes,
if I
Mr.
may,
Taylor.
Mr. Jewell, I hate to interrupt. But the point I'm trying to make is the same point I made at the beginning of this hearing. I think if you operate in a vacuum leading to the date of February 28th, you can jump to the wrong conclusion as to what the role of this nation and those people hired by this nation to enforce this nation's laws have taken place. Do you, who are the most familiar with what happened to your daughter and what you tried to prevent from continuing to happen to your daughter, don't you think that this body needs to know what went on at that compound prior to February 28th?
Absolutely, sir.
May I turn it to Mr. Barber, as a local law enforcement agent who turned and asked the ATF to augment the efforts of your agency. Do you feel like the law was being broken on a regular basis at that compound prior to your calling in the ATF to help out your agency?
We had a lot of accusations and suspicions, but we did not have probable cause on anything at that time.
Then, Mr. Barber, may I ask, why did you contact the ATF?
My primary concern was the hand grenades.
Okay. Mr. Jewell, if I may return to you, would you please inform this committee of some of the things that you brought to the Michigan court's attention when that court ruled that your daughter could no longer be brought in the presence of David Koresh?
On or about the morning of Halloween in, I believe it was 1991. And again, I'm speaking somewhat impromptu here, so my dates may be somewhat shuffled, but I received a call very early in the morning, and it was from Mr. Mark Bro, whose name was raised earlier. He identified himself to me, and he said, Mr. Jewell, I have nothing I can give you that would make you have a reason to believe me, but I hope you will. He said, do you know a Kiri Jewell? Because he wasn't even sure that he had contacted the right person. I said, yes, she's my former wife. And your daughter is Kiri? I said, yes. He said, sir, I have reason to believe that your daughter is in danger. And at that point, he had my full attention. And he began to tell me about the fact that he was a former member and that he, in fact, had been placed fairly highly in the hierarchy of David Koresh's organization. And he began to tell me who David Koresh was and what he was intending to do, not just with my daughter. I learned at that point that David Koresh intended to take my then 9-year-old daughter as his, maybe 10-year-old daughter as his wife, but that he also had plans to destroy the earth. And I must say that I feel a little uneasy using that phrase in the chambers of the United States Congress because it seems so preposterous. But if you believe it, it's not preposterous. The David Koresh that I came to know of and who I spoke with twice on the telephone was a man of absolutely unparalleled evil intent. It was his plan to bring about any circumstances necessary that would start a war between he and his followers and the rest of the world. Over a period of years prior to my conversation with David Koresh, with Mark Bro, excuse me, I had information that would come to me slowly and in little bits and pieces from my former wife, Kiri Jewell, who died in that fire, and from my daughter about what it was they were studying and what they believed and the things that were going to happen. And I heard about wars that they were going to be involved in that would cause literal rivers of blood. And I heard about friends supposedly being told that if they didn't come and join the group, that they would be killed. I have sworn affidavits in the possession of my attorney that refer to the remarks that Mrs. Slaughter was making earlier about babies being beaten at the age of 8 months old until their buttocks bled. And I don't refer to one affidavit, I refer to several. I have testimony about women being held captive for months at a time and being systematically raped and demoralized to the point where they would then consent to the will of David Koresh and or his henchmen. David Koresh perhaps truly believed that he was the incarnation of some deity or some power, but it was not heavenly.
Mr. Taylor, your time has expired here.
Mr. Chairman, if I may, I have two requests that I think are very pertinent. Number one, since Mr. Jewell's time was very limited, I would request that the testimony involved in the trial in Michigan, where he sought custody of his child and to prevent his child from falling into the hands of David Koresh, that be included in this testimony, for the sake of brevity.
If you can make it, provide it, it will be done without objection.
Secondly, Mr. Chairman, I have an opening statement that I would like to include in the record.
Without objection, it's so included. Mr. Hyde, you are recognized for 5 minutes.
I thank you, and I'm pleased to yield my 5 minutes to Mr. Schiff.
I thank the chairman of the committee for yielding. I'd like to take a moment, Mr. Chairman, to put in focus a couple of important issues here. First of all, just as the alcohol, tobacco, and firearms investigation and raid never involved Mr. Koresh's personal practices, however outrageous they were, with girls the age of Kiri Jewell, they never involved an allegation of child abuse in spanking young infants, which of course would be equally outrageous if in fact it occurred. The alcohol, tobacco, and firearms search warrant and arrest warrant dealt exclusively with firearms violations. And I would ask my colleagues who are listening and here today to decide if the other information that is constantly dumped into the middle of this hearing is relevant to the issues we must ultimately arrive at here. Second of all, I'd like to focus on the search warrant. Now, I'm not going to ask further academic questions about the search warrant, but I want to make the point that I think its relevancy to this hearing has been missed. In my mind, its relevancy to this hearing is not whether it legally established probable cause. I think it's possible that it did. But I think there are other aspects of the search warrant which are more relevant to what we're studying today, which is the activities of federal law enforcement agencies in this situation. And those other aspects are first, it was put together, as a number of witnesses have testified, in a prejudicial and inflammatory manner. And second, by the fact that no matter whose copy of the name of the offense is correct, it clearly misstates the U.S. Code statute number for the offense charged, and I think makes other technical mistakes in the law, which means to me it was put together in a sloppy fashion. Now, you put together inflammatory with sloppy, that translates to me that ATF was in a hurry to make a big splash with something. And I think that if that's true, and we have 7.5 more days to determine that, I think if that's true, that is substandard performance. And we'll hear from them, and they'll have a chance to explain. Now, with that, I'd like to use the balance of my 5 minutes to ask a few further questions. Deputy Barber, during the course of this investigation, I assume you met a number of ATF personnel.
That's correct.
Did you meet any of their public relations people who came to the scene before the raid?
Yes, I believe one, I think her first name was Sharon Wheeler.
Right. You know that she's I believe she's in public relations for ATF?
Yes, I knew that.
And you know, and they brought her there before the raid, I believe?
I met her the day of the raid.
The day of?
The day of, yes.
Do you know when she arrived?
No, I don't.
All right. Let me turn now to Mr. McMahon. Mr. McMahon, when you did business with Mr. Koresh in firearms, where did you do business?
I sold him some guns from my home. My licensed premise was my home.
From your licensed premises was your home?
Yes, sir.
And you didn't live on the Branch Davidian compound?
No, sir.
So he came to your home?
Sometimes, and sometimes I go out there and see him.
But he'd be willing to come to your home?
Sure.
Did he come to your home regularly?
I mean, maybe once every 3 or 4 months or so, but...
Okay. Let me turn to Mr. Thibodeau. Mr. Thibodeau, at the time that the raid first took place, February 28th, the ATF is arriving. Mr. Koresh knew the ATF, before that, Mr. Koresh knew the ATF was coming, in your opinion?
Before...
Well, did Mr. Koresh know the raid was going to occur before it occurred?
I think that when David Jones came in with that information, yes, he knew.
And how long was that before the raid?
I'm not really sure. It's been said 45 minutes.
All right. And David Jones was a mailman who belonged to the Branch Davidian sect?
Yeah, he lived there off and on. He had a property outside, but he was frequently coming in. His whole family was there.
Do you know where he got the information from?
As I said previously, it appeared to be from a news truck that was at the end of the, and this is from what I heard in the press, a news truck that was at the end of the road, and they were asking directions. Are we anywhere near the Branch Davidian compound or the house or whatever? I don't know what they said to him. And
I know you're not directly the witness here, but as far as you know, Mr. Jones was asked for directions to the Branch Davidian compound from a news truck.
No, the news truck was asking him. I think he pulled over seeing the news truck and said, hey, you know, what's going on? And being a mailman, they automatically assumed, oh, this guy's all right. Well, you know, we're looking for maybe you could help us. I believe it was that kind of thing. Could you tell us where the Branch Davidian...
Do you know who told the news truck that there was something that was going to be newsworthy happening there very soon?
I don't know for certain. It would sound to me like that would be the ATF.
Okay. And since you won't be here for the testimony about the raid, one last question. From the best of your recollection, would you say again, from which direction, front, back, up or down, do you believe the first shots were fired from?
I personally believe from the front, but it didn't take long after the front began to the back, so I would think it was pretty close to simultaneously. And may I make a statement?
Please, if it's brief, because I'm out of time.
In the past, we've all been put through the ringer on this whole thing, okay? And time again, I've seen things like the Donahue shows and some of these shows, and it's never a fair forum. And I kind of feel cheated here today because I have some specific things that I'd like to address. A lot of these points that were made can be addressed in counterpoints, and I've not been allowed to give that testimony, and I don't think anybody else, any of the other survivors have been allowed yet, and I really, truly hope we have that opportunity to address some of these points that have been made here
Are you able
today.
to return to this hearing at some point, Mr. Thibodeau?
Yes, I am, absolutely.
Well, I'd let you work that out with the chairman, then yield back.
If I might, your time is up, Mr. Schiff, and we may be able to give you some of that opportunity here. The panel is going to be recessed because we have a vote. We are going to take a recess, this joint committee. Mr. Conyers will have his 5 minutes next. If Mr. Klinger comes back his, perhaps between the two of them there will be that opportunity. If there's not, then we'll have to, or Ms. Collins might come back. If not, why, we will have to find another alternative. Thank you very much. We'll be in recess till after this vote.
You're watching the first day of Waco hearings before the House Joint Oversight and Judiciary Committee. We'll return in a moment, but first, some program information. Our companion network, C-SPAN 2, welcomes over 3,800 new subscribers at TCI Cable in Boyne City, Michigan. TCI joins cable companies all across the country, adding C-SPAN 2 to their systems. Our companion network's public affairs programs and live coverage of the U.S. Senate can now be viewed by 39 million cable television subscribers. Thursday morning, live at 7 Eastern Time, our Washington Journal. The C-SPAN school bus will be at the Pentagon. Guests for our newspaper roundtable, Republican Congresswoman Tilly Fowler and Democratic Representative Ike Skelton. Live Thursday morning, here on C-SPAN. C-SPAN, a public service created by America's cable television companies. We continue now with the Waco investigation, the first day of hearings before a House Joint Subcommittee. Chairing the hearing, Republican Bill Zelliff of New Hampshire and Republican Bill McCollum of Florida.
The subcommittee is called to order. We have just a couple of more questions of some witnesses, a couple more questioners who are here. We really have three more, one chairman and two ranking members, chairman of the full oversight committee. I was prepared to go to Mr. Conyers, and I will next, but Ms. Collins has agreed, and I think, Mr. Conyers, if you would, Mr. Barber has to run out. I don't know if either of you have questions of Mr. Barber, but he's got to catch a plane. I have a question Mr. Klinger is going to yield to me to ask, and out of comedy to this, if you don't have any questions, Mr. Barber?
No, I don't.
Nobody does, and I would ask with unanimous consent then that Mr. Klinger could have some portion, a minute of his time to yield to me, and I'll ask Mr. Barber.
I would be delighted to yield to the chairman.
Thank you very much. Mr. Barber, I just want to clarify something completely for the record. I asked you some questions, and then some more were followed up at the end here by some other people today about the grenades and about drug labs and all of that. My understanding is that from your testimony that the reason you primarily turned over, maybe the only reason I think you said you turned over the case or called up ATF was because of these grenades that the UPS folks had gotten or found or whatever in the mail system. Is that correct? I just want to corroborate that.
It was a combination of the grenade bodies and the explosives materials that they were receiving.
But the bottom line is those grenade bodies, as I understand it, were bodies. There was some evidence there were other material there, but the bodies themselves were not live grenades. Is that correct?
They were not live grenades the first time I saw them. No, they weren't.
And what other material were you concerned about besides the grenades, besides these grenade bodies, we call it?
It was the potassium nitrate and the powdered metals.
Now, where had you been aware of those from? What was your source for that information?
Graduating from the bomb technician school at Redstone,
But no,
Alabama.
I mean, how did you know they were getting that stuff?
That was also obtained from UPS.
That material was obtained from the UPS?
The documentation was.
But you didn't have any of the, you had some of the grenade bodies, but you didn't have any of the chemicals.
No, sir, I did not have any of those.
Yeah, you're just listening to UPS fellows talk about delivering stuff out there.
And I would actually get a copy of the receipt.
Okay. Last question, and again, just to clarify it, you told me earlier that several years before the raid, there was some evidence of a methamphetamine lab, but there was nothing current at that time. There was no current evidence within the last year or so, to your knowledge, of any other drug activity, production of drugs, or any of that sort of thing on the compound problem, was there, or proper, was there?
No, sir, not to my knowledge.
All right. I don't have any other questions into Mr. Barber, and if I'm going to yield back to Mr. Klinger to reserve the balance of his time, which I think is 3.5 minutes at this point. And I would yield then to Mr. Conyers is ready for his 5 minutes to Mr. Conyers. Mr. Barber, you're excused. Hope you can catch your plane. Thank you very much for coming and being with us. Mr. Conyers?
Thank you, Mr. Chairman. And I compliment you, as I have, about the fairness in which you conducted the hearing, and Mr. Zimmer as well. And I'm hoping that we can resolve the outstanding question of the subpoenas this evening after we've concluded our activity. Let me just ask Mr. Thibodeau a yes or no answer as to whether the NRA or anyone on its behalf has contacted you in connection with this hearing?
No.
In any way?
Not NRA, no.
All right. Mr. McMahon, may I ask you that same question, please?
Yes, sir. Those were the only people that wished to hear the truth.
You say yes, you have been contacted?
I was contacted, like right after the raid and fire. This was a while back.
No, I meant in connection with the hearing that we're having today.
Oh. Yes, sir, I have been contacted.
Sure. And can you give us a little idea of when you were contacted? Well, I mean, was it yesterday?
Have I talked to him yesterday?
Yes.
I did talk to them yesterday.
Sure.
I talked to him
And was it the
months
day
ago, too.
before?
The day before?
Yes, the
No,
day before yesterday.
No, sir, I didn't get the letter to come here till yesterday.
I see. And what was the nature of the discussion between you and them?
Just what will I be doing there? What's going on? I mean, I didn't testify in front of a trial or anything. It's the first time I've been in front of anybody.
I understand.
And I want to know what's going on.
Let me ask you this. Who was it that you talked to there?
I talked to Jim Warner, Mr. Warner. I thought about the name of Mr. Warner.
Right. Right. The Deputy General Counsel.
I believe you. I don't
He
know.
sounded like a lawyer? Okay, let's move on. We'll get more. I'd like to ask you to amplify that, but we don't have time in the period of 5 minutes. What I need to bring to this part of our hearing is that just recently in the GOP contract with America, and specifically H.R. 666, we voted out a bill with nearly unanimous Republican support that didn't require that we have exceptions to the exclusionary rule, good faith exceptions. We said that we went a lot further than that. They did, not me. And said that we would throw the whole warrant requirement out of the window if this part of the contract on America becomes law, because we would have an expedited exemption to the whole exclusionary rule. We pointed out that this was eroding the whole Constitution. And now I am so pleased to find that the same people that voted to further erode the exclusionary rule of which Mr. Goldstein has very adequately complained of, are now very worried that there aren't teeth in it, there wasn't enough, it was very shoddy, and now we have this incredible conflict. The bill the crime bill we passed out says warrants aren't even needed for searches. It says there's no need for a magistrate to determine whether there's probable cause. It gives total discretion of probable cause to the law enforcement authorities. As long as they believed that there was probable cause, then no warrant would be required at all. That's the law coming down the pike. Now, Mr. Deschamps, before drawing up his affidavit, Agent Aguilar had spoken with several former compound residents who told him there were machine guns at the compound. He also spoke with firearm dealers who told him they had delivered kits that could be converted, convert semi-automatic guns into automatic weapons. He spoke with a UPS employee who saw a hand grenade fall out of a package before being delivered to the compound. He spoke with Lieutenant Barber, who told him that a rancher living near the compound had heard machine gun fire. After the raid, machine guns and hand grenades were found. Is there any case law anywhere that would say that such a factual predicate could, under any circumstances, be insufficient for probable cause in order to obtain a warrant?
I'm certainly not aware of any such case law.
Mr. Cummings is gone.
Well, I want to thank all of the witnesses, and I'm hopeful that Mr. Jewell, who had not completed his testimony with Mr. Taylor, would be given an opportunity to do so, because I wanted to hopefully ask him, Mr. Chairman, who I praise for such eminent fairness, that did Mr. Koresh personally tell you that if the authorities ever came after him, he'd shoot them?
Well, it may be that we can let Mr. Jewell answer a question like that after we're done, if Mr. Thibodeau is also given a couple of minutes who wants to say something too. So, but let's see what happens in our time. We've got a whole other panel.
You don't think that's a very important question?
Well, I think it's an important question. I think what maybe Mr. Thibodeau wants to say is important too, but we've got to be judicious. Mr. Klinger has 3.5 minutes left. and I yield to him.
I thank the chairman for yielding, and I apologize for not having been here to listen to the testimony. And I just have one question, and I'm going to yield the balance of my time to the vice chairman of the committee who has been here for the entire testimony, Mr. Schiff. But my question would be to Mr. McMahon, and I think you indicated that you had been in, had conversations with the representative of the NRA.
I have.
And my question is simply this: was there an attempt made to influence or direct your testimony? Were you in any way influenced in the way you were supposed to testify here today?
No, sir, they did not.
I thank you very much. And at this point, I would like to yield the balance of my time to Mr. Schiff.
Thank you, gentlemen, for yielding. Mr. Thibodeau, you indicated that there were several points that you thought could be and should be refuted. On what subjects? About what?
Okay, the first subject that I think needs to be brought out is the fact that in 1992, not the federal government, but the state authorities came and investigated the children, and they went through the signs of the physical, the mental, and the sexual abuse, and they couldn't find any, and they dropped their case.
Didn't a state official actually come out to the compound?
Yes, that is correct.
Was the state official fired on by anyone?
Absolutely not.
Was the state official
They came out with a sheriff's
in
department.
prison so that he or she, I believe she in this case, couldn't leave?
No. She was free to come and go.
Okay, thank you. Go ahead.
And as a matter of fact, when asked about the underground bus, David Koresh took her down there and showed it to her. So, I mean, from what my understanding was, he pretty much opened the place up to her. But anyway, they found no signs of the abuse that's been discussed, and they dropped their case. The next day in the Waco Tribune-Herald, the health people said that these were the nicest, most well-behaved children we've ever had the pleasure to work with. And, you know, I think if we're going to check out the child abuse issue, that's a pretty powerful statement for a health worker to make for kids that are abused readily, as we've heard.
Well,
and also the Sheriff's
I
Department.
just want to say that the child abuse issue, in my judgment, has absolutely nothing to do with this hearing.
I agree with you 100%.
Because it was not a matter that was being investigated by federal law enforcement. Doesn't mean it's not an important issue. But since it's been brought up time and time again, I thank you at least for putting in the other side. Go ahead, please.
Well, yeah, one more thing. The Sheriff's Department also came out with them. And the next day in the press, David spent a lot of time talking with the people from the Sheriff's Department because of what happened in 1987 with George Roden. He felt he was misfairly treated. But he spent a long time talking to them, invited them out later on to go fishing or whatnot.
I'm sorry.
He invited the Sheriff's Department, some of the Sheriff's Department officials, I do not know the names.
But who invited the
Koresh
Sheriff?
did himself. When they came out with the health workers. And they said the next day in the Waco Tribune-Herald that the only problem with the people out there in Mount Carmel is that they're misunderstood. You know, I mean, these are quotes from the legal representation of McLennan County, and I think it's pretty much well documented that David Koresh knew Jack Harwell, the sheriff, on a first-name basis. And I think that the ATF definitely should have gone through Jack and come out with the sheriff to knock on the door and not, by the way, the search warrant, if I just may say this really quick, that was a knock search warrant. You're supposed to go to the door, knock on the door, and present it. I don't understand how you can serve a knock search warrant with helicopters coming into the back, 3 different groups of ATF agents, one going up the side to throw in flashbang grenades to get the evidence, while another team goes and shoots the dogs, while yet another team is going to the front door to serve the warrant. That's spontaneous. It's happening at once, and that is not. And you can get a no-knock search warrant, sir, if my understanding is correct. They did not have one, and I don't understand why they would choose a dynamic entry with having a knock search warrant.
Well, let me go back to the Sheriff's Department. Are you saying that sheriff's officials were invited out to the compound?
Yes.
You actually saw them there?
No, they never came out later, but David always made the invitation open to them to come out if they wanted to fish on our pond, because we had a stock bass pond.
All right, so he wasn't hesitant about having law enforcement agents there?
No, and you know, there was one more interesting incident I just thought of. When the initial reports came in about all these automatic weapons, Steve Schneider actually went into the Sheriff's Department and put a Hellfire trigger switch on the desk and said, "This is legal, I believe, under the ATF." That's probably what you heard out there. Now, you know, I'm not saying that's right or wrong, sir. All I'm saying is that all the way along, Koresh tried to work with law enforcement. And I know this from experience. Koresh always tried to work with people.
Your time has expired.
All right, I thank the chair.
At this time, I will yield 5 minutes to Ms. Collins.
Mr. Chairman, before the clock starts running, I need to ask for some verification, and I'll tell you what it is. I have a split-second yes or no answer that I'd like, then I'd like to yield another 15 seconds to Mr. Conyers, and then 2 minutes to Mr. Gene Green, and 2 minutes to Sheila Jackson-Lee. I don't have a time watch here, and you're going to take the time?
We'll take care of it. We'll do our best.
I just wanted to make sure, because I know those lights go off real fast.
Yeah, well, we'll do our best. Maybe we'll do this by hand. We'll do our own stopwatch over here. You get going now. I'll yield to you now. Your clock starts running right now.
Okay. Thank you, Mr. Chairman. I yield to Mr.
Thank you, Ms. Collins. First of all, Mr. McMahon, would you give us by tonight some statement about your contact with the NRA that we were discussing, please?
Yes or no?
No, that wasn't a question. I was asking him to do that. Okay?
I don't understand why. Are you saying, are you ordering me to, or are you saying do it, or are you saying
Yes, I would like you to do it, please.
I'll consider.
Okay.
I think the time is up that she's yielded to you. She wants to yield.
Let me quickly ask Mr. Thibodeau, on Turning Point last Thursday night on ABC, you testified that you saw Koresh when the raid occurred. You saw Mr. Koresh hold out his hand and said, let's talk about this.
Okay.
Do you remember that testimony?
Yes, I do remember that testimony.
And today you said you were nowhere near the door with him, that you were way at the back of the room.
Because what I said with that testimony, sir, Mr. Conyers, what I said with that testimony is I said that I heard from 3 separate eyewitnesses who were at the front door that told me the same thing, that is exactly what occurred.
You didn't see
No,
it?
I made that clear that I was not at the front door, but that eyewitness testimony told me.
Mr. Jewell, can you tell me, from your own knowledge, what perhaps Mr. Koresh told you he would do if authorities ever came after him?
I will try to make this as short an answer as I possibly can, but over a period of years in trying to maintain contact with my daughter, I have called the compound and twice got Mr. Koresh on the phone and was engaged in a conversation with him. Mr. Koresh and I shared a common religious ancestry in that we were both raised Seventh-day Adventists. We had that in common, and as Seventh-day Adventists we understood that in the time of the end that God's people would be persecuted and perhaps put to death. He told me during the course of that conversation that that was true. However, when they came after him and his people, they were going to fight back and kill anybody that they had to.
Thank you very much. I yield to Mr. Green, Gene Green. No,
Appreciate the ranking member of my committee yielding time to me. I don't know if we still have the grenade paperweight that was shown earlier, and maybe it's just because I'm from Texas and I've seen them before in Army surplus stores, but I don't have a case of them. and Mr. Mahon, if you could tell me, we heard testimony from Mr. Barber about UPS saying that there were cases of those paperweights that were delivered, and that was one of the reasons for his concern in calling in ATF. In your experience as a firearms dealer, do you know of at that location if they were using those hollow grenades to pack explosives in?
I never seen any hollow grenades. I never seen them out there. I have seen those type of grenades at gun shows as a paperweight, but I have never seen any at David's.
Okay, so you saw none of them. Do you know of any of them that have ever been used to pack explosives in and then use them as a grenade?
By the Branch Davidians?
No. Do you know if that's available? Is that possible?
I guess it's possible. I mean, I'm not qualified to answer that.
I reclaim my time. I yield remaining time to Sheila Jackson-Lee.
Thank you very much, and I imagine I have to talk like the speeding bullet. I hate to use that terminology. Let me say how proud I am of Kiri. I have a 15-year-old, and you've stood here so long. Mr. Jewell, if you can help me, you said very clearly you're not a theologian, you're not a pastor, but we talk about this is for the American people, and people hear the word religion, and they hear the fact that we should in this country respect it. Help me understand from what your daughter went through, would you say that he had gone beyond and that we had reached now a point of a cult? What is your sense of it? And I have a quick question for Mr. McMahon, and you see how fast I'm going.
The one thing that I think God expects of us is that we use our own minds to develop ourselves and become everything that we can be. That differs from what it is my understanding that David Koresh encouraged his followers to do, in that he encouraged them to listen only to him, and he could change his mind anytime he wanted to, and his word was still law.
I think for the American people that's important, because you've mentioned a certain religion, and I would not want it to be indicted for what really was a true cult and took away the minds of people. Mr. McMahon, did you visit Mr. Koresh in the compound?
At David's house? Yes, ma'am, I did.
And you just mentioned, was that his home?
Yes, ma'am.
Were there women and children there?
Yes, ma'am.
Were there some children under 5?
I would think so. Sharon spent most of the time with the
Was
kids.
he a licensed gun dealer?
No, ma'am. Not that I know
Would
of.
you say that, could you describe maybe the amount of weapons that were in the home there, or maybe as much as you sold him?
I just turned a list into.
Just give me a.
I sold him around 223 guns.
Pardon me?
I sold him around 223 guns.
Would that be the average amount of weapons you find in normal American families' homes? Would you have any way of estimating that?
No way of estimating. I mean, they have estimated it to be like 3 guns per person, and that is below the average.
And if there,
That
this,
is below the
however,
average.
is a home, children, wives, and you said 223 that you sold, and of course that doesn't account for what else he might have had. Let me move, and thank you very much for that, but that was his home.
I think I've been very liberal about
Have you
the
been
time.
liberal? And I've got so many more questions. But
Well,
Mr.
I
Chairman,
know,
Mr.
but
Chairman,
yes,
Let me
Ms. Collins.
thank you for being so liberal with your time. You have certainly been very fair and have extended time, and I greatly appreciate it.
Well, you're quite welcome, and it's been a pleasure today. I think I pretty
I
well.
do as well, Mr. Chairman. I hope that our earlier question about being able to ask questions will be considered. Thank you.
Well, we're doing our best here. I think that we have pretty well completed all the formal questions we're supposed to have. If we let this continue, we'll never get to another panel. And as I have questions I'd like to ask, actually, but nonetheless, I think they can be submitted in writing, and any of you who want to submit them, please do. And somebody asked earlier about statements. Before I release this panel and turn the gavel over to Mr. Zeloff, I want to make sure everybody understands, without objection, anybody's statement, any of the witnesses and any of the panel member statements may be submitted for the record. Mr. Thibodeau, you had wanted to make a statement on the record.
Yeah.
We don't have time. No one's got a question.
May I submit them in writing?
You may submit it in writing, absolutely.
Thank you
may
very
submit it
much.
in writing. And we've done the best through Mr. Schiff we could to give you some verbal time. With that in mind, Ms. Thurman?
And of course, that would be offered to all of the witnesses,
All the
here
witnesses,
today.
I
that we
just
would
made that
hold
statement.
this-
All of the witnesses have a right to submit a statement in writing if
How
they
long
desire.
will we hold the record open for?
Well, the record's certainly going to be open through the period at least at the time of the hearings, which are over a period of the next couple of weeks. So
Right.
certainly through the end of this month, I would suggest they'll be open.
Mr. Chairman.
Yes, Mr. Micah.
Just a question, a parliamentary inquiry. I have a copy of Ms. Jewell's notes or statements. I wasn't in when she testified, and I wondered if this statement had been made a part of the record, and also, Mr. Chairman, when this was presented.
Well, if I might say, if you were not here, the record will reflect that Ms. Thurman was asking the question. She asked Ms. Jewell to read the entire statement, and she read it verbatim. So it has been read into the record, Mr. Micah.
But when was it given to the committee?
I believe the committee received it this morning, or this afternoon?
At the time she was speaking.
Well, it was before that she spoke, but during this morning.
Because I didn't see that our side had this.
This morning, I know they were at the desks here this morning. Well, for those parliamentary inquiries, I want to thank this particular panel. You've been very gracious. You've spent your time. Some of you have had some pretty tough questions to answer, but we thank you very much for coming. And now I'm going to turn the gavel back over to my co-chairman, Mr. Zeloff, and for the last panel of the day. Thank you.
Okay, I'd like to thank this panel and have the next panel come forward to be seated and sworn in.
Sure gets 15, so he's right there. Let's get it all together. Yeah. I want to swear on that sheet. It is first.
Oh, I'm sorry.
Okay.
Okay. While you are proceeding to the witness table,
Can we kind of keep it? You guys keep it down a little bit.
I'd like to Okay. In the order that I call everybody and introduce you, it'd be on your right, my left. I'll start out with Davey Aguilera, is a Bureau... Okay. David? On your far right, my left. He is a Bureau of Alcohol, Tobacco, and Firearms Special Agent. Chuck Sarabin is the former Bureau of Alcohol, Tobacco, and Firearms Special Agent in charge in Houston. Earl Dunnigan is the former Bureau of Alcohol, Tobacco, and Firearms Special Agent in charge in Houston. Bill Johnson is the Assistant U.S. Attorney in Waco, Texas. Dan Hartnett is the former Bureau of Alcohol, Tobacco, and Firearms Deputy Director for Enforcement. Ed Owen is a firearms expert for the Bureau of Alcohol, Tobacco, and Firearms. H. Jeffrey Moulton, Jr. was the Project Director of the Treasury Department Review Team. Dr. Bruce Perry is an Associate Professor of Psychiatry and Behavioral Sciences at Baylor Medical College. Thank you, gentlemen. Raise your right hand. Do you solemnly swear that the testimony you're about to give to these subcommittees is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Let the record show that the answer was in the affirmative. Okay. I know that each of you come with a... Chuck? Each of you comes with a very special story. We appreciate your being here. Some of you appear on future panels during these hearings to address different concerns. Today, by previous agreement, we will try to focus on the investigation and the warrants portion, and we'll begin with questions. The Chair now recognizes the Vice Chair of our National Security Subcommittee and my friend Robert Ehrlich of Maryland for the...
Thank you, Mr. Chairman. And thank you all for appearing before us today. Before I begin my formal remarks, I would just like to make a couple points. Yes.
We have rechanged the order, and I apologize. Would you be willing to hold off?
Sure.
What I'd like to do is have our colleague, Mr. Barr, 15 minutes first.
Thank you, Mr. Chairman. Mr. Johnson, is it Johnson or Johnston?
It's actually Johnston with a T.
That's what I thought. You have a law degree?
Yes, sir.
And you serve as a assistant United States attorney, a prosecutor?
Yes, sir, I do.
Okay. I have a law degree and I served as a U.S. attorney, so we have two things in common. I suspect we have something else in common, and that is neither of us are particularly enamored of Mr. David Koresh. Am I correct in that we share that in common?
Based on what I know, he did some bad things.
Based on what I know, he did also. And I think that is something that we do have in common. Let me, if I could, Mr. Johnston, ask you a few questions. Define very succinctly for me dynamic entry.
I hadn't heard that term of dynamic entry
Neither had I.
I suppose it means some active movement in a search warrant.
Well, let me kind of back up then. Do you know what the term dynamic entry means?
I could give you a definition that I think it means.
Okay.
Shall I?
Please.
A search warrant or a...
Could you pull that mic up?
Yes. Yes, sir. Police activity in connection with a search warrant that involves an entry where their persons are not invited in other words, as opposed to like where police call ahead of time and are invited in or do some low profile entry. It would be more in the nature of a moving search warrant like you might see on television where agents are running instead of walking and so forth.
Was the entry in this case a dynamic entry?
I wasn't there, but based on what I've seen on television, in keeping with the definition I've just given, I think it was.
Okay. You were not at the scene?
No, sir.
Okay. And did you have any discussions at any time prior to the dynamic entry or whatever it was on February 28th of 1993 with ATF concerning a dynamic entry?
Not concerning that term. They discussed They mentioned almost in passing that they were going to do something I learned in the nature of having agents in cattle trailers. I didn't know the details of the raid plan.
Okay. Are you familiar with testimony in a previous court case concerning efforts by a defense attorney to raise questions with a witness as to whether or not you had told them that your office or you would not approve a search warrant or an affidavit in support of a search warrant unless it contemplated a dynamic entry?
I have, and it's a gross mischaracterization of anything I said.
You're familiar with that?
Yes,
in
sir.
prior
I heard
court
it during the trial. Yes, sir.
Okay. Would it be fair to say, Mr. Johnston, that the purpose of an investigation in support of a potential prosecution involves an effort to see that justice is done?
Absolutely.
Would you share with me a concern that federal employees, whether they're involved in law enforcement or non-law enforcement activities, if they violate the law or engage in wrongdoing, that they should be prosecuted and brought to justice?
Absolutely.
And would you also agree with me that an effort to do so through an internal, that is, within the government investigation, ought to be a search for the truth?
I think any investigation ought to be a search for the truth, or it's not much of an investigation.
Certainly one involving allegations of wrongdoing on the part of officials sworn to uphold the law.
Yes, sir.
Okay. With that in mind, then, I would ask you, would it be appropriate in a investigation of alleged wrongdoing by federal officials that the government deliberately and explicitly direct that evidence not be gathered, that witnesses not be interviewed, that no record of interviews be kept, that the passage of time hopefully will cause witnesses' memories to dim? Would that be a fair search for the truth, or would that be more in the nature of damage control or a cover-up?
Well, what you're describing doesn't sound like, and I don't know if you're asking that in hypothetical with reference to this case, sir.
It's not hypothetical, and I'm going to show you some documents that establish it's not hypothetical. If I could have a clerk. If you would, please, Mr. Johnson. These are 3 documents which were contained in the documents made available to this body by virtue of the subpoenas. One is a memo from a Robert McNamara to John Simpson and others, Treasury Department, dated 14 April 1993, subject preliminary investigative plan. It says that this is law enforcement sensitive, and it involves an investigation of ATF. And it states on page 2, quote, DOJ does not want Treasury to conduct any interviews or have discussions with any of the participants who may be potential witnesses. Then later in that same subparagraph, it talks about, while we may be able to wait for some of them, witnesses, to have testified in the criminal trial, the passage of time will dim memories. Then later on, it states at the very bottom of page 2, the prosecutors are concerned that anything negative, even preliminary, could be grist for the defense mill. And that document goes on. Another of the documents that you have before you is another Treasury Department document, this one from Ron Noble, Assistant Secretary for Enforcement, dated September 17, 1993. And it reflects an interview that took place on March 1, 1993. And I quote, ATF initiates a shooting review. And then it goes on. Troy tells review they immediately determined that these stories did not add up. That is, interviews with Rodriguez, Maston, Konecki, Kavanaugh, Sarabin. Then it says Johnston, at this point, advised Hartnett to stop the ATF shooting review because ATF was creating Brady material, because Konecki had not yet been interviewed, Johnston authorized that interview, but no notes were created. A third document, which you have before you, is another Department of Justice document dated April 9, 1993, again from Robert McNamara to Ron Noble. While the subject matter at the beginning of that document has to do with Waco press release, in the middle of it, it says, Justice prosecutors in Washington and in Waco said that any words which could be interpreted as being critical of ATF must be avoided, since it would play into the defense attorney's hands and aid the defense attorneys in making ATF the issue. And then that document goes on. There are some other documents that I have before me, and I'll make these available. These are not as clear as these typewritten documents. They are notes that, again, were furnished to us pursuant to subpoena. And if I could have a clerk deliver those to Mr. Johnston, please. One reads as follows, and this is document number 000-14137. It says, T Rangers, perhaps for Texas Rangers, Ray Yan does not want them, Kolnacki, Phil, Ray, interviewed because John does not want any more exculpatory statements generated. The other one I think that we've already dealt with in previous testimony had to do with Mr. Yan advising Ron Noble not to open an envelope. And the final one here involves, again, and I apologize for the lack of clarity, but we have to deal with what we have. It again involves some handwritten notes. The first word at the top of the page looks like Leroy, and it says, statements from agents, AGTS, I presume that means agents. Should they go to USA, which I presume is United States Attorney, or us, do they want us to create new, and then there's a blank, and then it concludes by saying, asking questions to which would require us to create new documents. Parenthetically, it says exculpatory. These documents, to me, Mr. Johnston, raise very troubling questions about what was going on here. We heard at the very beginning today an article here in the paper talking about damage control, and this is dated today, July 19th. And I have some very serious concerns here that this started a long time ago. And I have a background as a prosecutor, and I would presume that these sorts of memos, and I know you didn't generate them, at least it doesn't appear that you did. They came from another lawyer at the Department of Justice, Mr. McNamara, I believe, and I don't know who wrote the handwritten notes, but these are documents that were furnished by the government, presumably generated by the government as part of an investigation to determine, I suppose, among other things, what went wrong and what agents might have done wrong. I mean, we know that there were things done wrong. I mean, agents were terminated because of that, because of misstatements, because of misleading activities. Was this, I mean, what's going on here?
Okay. I cannot speak to the references to Ray and Leroy Yan. They were here, and it appears there are references to them in exculpatory matters. I was not concerned about exculpatory matters. The truth is the truth. I can speak to the note that has my name in it, which talks about Hardin and the shooting review. The typical protocol with ATF, my understanding is after an incident, a shooting incident occurs, a shooting review team is created, sometimes out of Washington, sometimes elsewhere. They normally go down and interview the agents. I don't know if it's normally recorded or not, but at least notes are taken. That process started. There were at least a couple of, there were some interviews, I don't know how many. This was in early March, I believe. It was fairly soon after the incident. ATF immediately received a great deal of criticism for what they had done, and it became obvious, at least to me, that ATF probably should not investigate ATF as far as the criminal case goes. And I don't have the authority to direct ATF to do something, but I did talk to, I think, Mr. Hartnett, I'm not sure, he can state whether or not, and told him that in line with our hope, or at that point it may have been a fact, the Texas Rangers have agreed to investigate this case. Let them investigate it, please. Because for ATF to interrogate ATF with the built-in bias and suspicion that already existed, I thought would be not healthy. I had no reason to think ATF would, in their own interviews, cover something up, but there were a lot of people that did. And the Texas Rangers, I believe, would be an objective, a qualified body to investigate it. And yes, sir, I asked the Rangers to do the investigation all in all. Now, for ATF to have come in and had a shooting review team member interview someone and have the Ranger come in 3 minutes behind and do the same thing, I thought was very imprudent. The Rangers, I believe, could ask questions, get straight answers, and develop the truth of what happened. And may I add, in terms of the timing of it, there's some, I feel you've alleged on someone's part, maybe mine, that I want people's memories to dim. In fact, I asked the Rangers to, I asked the Waco Police Department the night this happened to begin interviewing ATF agents before their memories dim. Waco police detectives, I could name 2 or 3, at my request went to the Hillcrest Hospital in Waco and taped interviews with agents while they were still on codeine and so forth. And the Rangers, I asked to, as quickly as they could, get interviewing, and they did, sir, and they were all audio taped and all made available. And there were some exculpatory...
Well, the reference to memories being dimmed was contained in this memo by Mr. McNamara. And it would be very interesting to ask him some of these questions. But in terms of your prosecutorial background, which from everything I can tell is exemplary, why would the federal government, first of all, be committing things like this to writing, but more importantly, why would they be deliberately directing that in terms of an internal investigation to uncover potential wrongdoing, why would they be explicitly directing that evidence not be accumulated, that interviews not be conducted, that when they are, perhaps there ought not to be any notes taken? I mean, why would that happen? And let me also say, I know as a prosecutor, Brady material can sometimes be a pain in the neck to deal with.
That's what happened. Those are the rules.
In court, but we have mechanisms for it. But it seems to me that the government was trying to cover something up here.
Well, I sure wasn't. In fact, I was trying to avoid the question of a cover-up. If ATF had done this investigation themselves, as I say, I have no reason to think they would have coached their own agents or would have suggested answers to their agents. But I thought it would have been a real easy thing to criticize, and quite objectively, because ATF was under attack so strongly, they may have bonded together in interviews. I don't know. I don't think they would have done it intentionally. But it was extremely important to have objectivity. My desire for the Rangers to do it was to seek the truth in the most unintimidating circumstance possible. In other words, so that the Rangers could ask ATF agents one-on-one, which they did, audio taped, everything that happened. And I felt the Rangers, the ATF agents would be comfortable talking to the Rangers, whereas they may not be comfortable talking to ATF supervisors and as Treasury Review. I'm sorry. Okay. I'll try to quickly finish the answer, sir, Mr. Chairman. Because there was conflict within ATF by this time, a lot of agents at the staging area felt element of surprise had been lost. There was a lot of conflict. The shooting review teams are often comprised of people involved in supervisory capacities. There was conflict between line agents and supervisors, and I felt to give it the best chance of being a truthful interview of each agent, the Rangers should do it, sir. And as to Brady, I'm not afraid of Brady. As to exculpatory matters, I'm not afraid of exculpatory matters and was not.
Well, Your sentiments do not seem reflected at all in these documents.
I
and
certainly
think,
didn't create them, sir.
These certainly will be looked into further. I thank the chairman, and I thank Mr. Johnson.
They're going to do it. Thank you. I think what we're going to... Anybody know how long this vote's going to be? How many votes?
15 minutes.
One 15-minute vote? Okay, we're going to recess for 15 minutes. We have a vote, and we'll be right back. Thank you.
We'll continue with the Waco investigation in a moment. But first, some program information.
Information about C-SPAN and public affairs is available on your personal computer through America Online. Get our daily program schedule, read the text of pending bills in Congress, and learn about C-SPAN in the classroom. To find out more about America Online, call 1-800-827-6364, extension 8665. If you're already an AOL subscriber, find the C-SPAN area by typing the keyword C-SPAN.
Sunday night, the latest developments on the road to the White House. Our weekly look ahead to the '96 presidential election brings you candidate forums, speeches, and campaign events. Road to the White House, Sunday at 7 and 10 p.m. Eastern and Pacific Time on C-SPAN, the political network of record. We now continue with the Waco investigation. The first day of hearings before a House Joint Subcommittee. Chairing the hearing, Republican Bill Zeliff of New Hampshire and Republican Bill McCollum of Florida.
Committees will come to order. The chair recognizes Mr. Schumer from New York for 15 minutes.
Thank you, Mr. Chairman. I want to thank all the witnesses for being here. I have a whole series of questions, but I would like to make one point first. I'm sorry most of my colleagues on the other side aren't here. We've heard a lot of talk about faulty warrants, search warrants, and you know that it might, some I might not have been dotted, some T might not have been crossed. If I'm not mistaken, these are the same folks, my colleagues to the right here, who voted to eliminate the need for search warrants with the good faith exception to the exclusionary rule. Now, I think that's, you know, I didn't support that. I can see an argument, but it does strike me as a little strange that just a few months ago, people voted that there should be good faith. No one doubts the good faith of the people here, and yet here we're making huge fuss about warrants not being perfect. It's the topsy-turvy nature of this hearing altogether. It's my belief that, as I said in my opening statement, that this idea of moral equivalence, that, well, here we have Koresh, and here we have ATF and FBI, and they're sort of the same. They've each made some mistakes. Maybe ATF is the villain, or FBI is the villain, and Koresh is a misunderstood guy, is going to lead the other side into trouble throughout these hearings, if that's their view, and it seems to me that is in many ways. Now I'd like to ask first Mr. Aguilera some questions. I want to focus on the warrant. First of all, Mr. Aguilera, how many warrants have you put together in your career as a ATF investigator?
Approximately 30 or more.
30. Have any ever been thrown out?
No, sir.
So you've had a 100% record in putting together decent warrants?
Yes, sir.
Warrants at least that met the tests that courts impose?
Yes, sir.
Thank you. And let me ask you this. What made you initiate the investigation of the possible manufacture of machine guns and explosives devices by Koresh and other members of the Davidians in the compound in Waco, and from whom did you receive the information? What got you into this is the vernacular question.
I received the information from Lieutenant Gene Barber from the McLennan County
This
Sheriff's
didn't come out of your head or some higher up in Washington or anything like that. This came from local law enforcement.
Yes, sir. That's correct.
And they don't call you very often to do something like this, do they?
No, sir.
This was because of the extreme nature of what Mr. Koresh was doing.
That's correct.
Okay. In your experiences, do people generally order cases and cases of grenade casings and then order the metal parts and the, what's it called, nitrate? No, it makes aluminum nitrate. I guess hydrogen nitrate or ammonium nitrate.
Potassium nitrate.
Potassium nitrate. Thank you. Do they do that? I mean, do they do that unless usually they have some kind of bad purpose in mind? How many times?
No, sir, not
No,
usually.
you don't need, just to clarify for the record, you don't need ammonium nitrate, magnesium, or aluminum powder to help a paperweight.
No, sir.
No, the casing alone might suffice for the paperweight. I thought so. Let me, even Mr. Zelliff is smiling at that question. Mr. Barr is not here. I wanted him to hear it, too. But in any case, okay, let me, I'm on a roll, right? Well, it's not hard to be on a roll when the facts are on your side. In any case, let me ask you, other than arms dealers, we saw one of the arms dealers, who else did you interview in an effort to find out if the Davidians possessed or were manufacturing illegal weapons, and what did you learn?
I interviewed numerous former Davidian members.
Right.
And I obtained...
I'm interested in the neighbor. Tell us a little about the neighbor, since we had wanted him to come testify, Mr. Cervenka, well, if I'm pronouncing his name correctly.
Yes, sir, Mr. Cervenka.
Cervenka. He's not allowed, so we'll have to rely on your testimony about
Yes, sir. I initially received the information from Gene Barber, who was told by Mr. Cervenka that he had heard machine gun fire throughout the evenings. And thereafter, I personally interviewed Mr. Cervenka, who told me the same thing.
Okay, thank you, Mr. Aguilera. At least I think the case has been made overwhelmingly that you met the appropriate standard in this warrant, and that we're getting some crocodile tears about it. My next questions come from Mr. Johnston, who I must say has a reputation of being a fine prosecutor. How many years have you been a prosecutor?
A little over 10 years, 8 years in the federal system.
How many search warrants have you reviewed?
Several hundred.
Okay. Did you feel that Special Agent Aguilera had done a good job on the investigation of violations in the firearms law at Davidian when you saw the warrant?
I felt he'd done a very good job, and the affidavit itself, while he gave the information and drafted it, it was worked on by assistant U.S. attorneys, including me, and there's been a lot of talk today about the sexual abuse being in the affidavit.
Yes, I was going to ask you that.
That was my call.
And why did you put it in there?
For a number of reasons, primarily a woman named Joy Sparks had given information.
Yeah, we've heard about her. She was interviewed by a member of the Waco committee team named Miss Haga.
There was quite a bit of information, I think a page or more, about Joy Sparks and the information she'd received. In and of itself, it didn't say they had machine guns, but it demonstrated that they had apparently had weapons. There was some threatening discussion by Koresh involving Ms. Sparks. Further, there was evidence of a buried school bus that may act as a shooting range. At any rate, to explain to the magistrate why Ms. Sparks was there, I made the decision to include in there why she was there. She was there to investigate allegations of sexual abuse of children. And the allegations of sexual abuse, in my mind, were referenced generally in the affidavit. Had I wanted to,
I don't mean to hurry up, but my 10 minutes,
okay.
And I got a lot of other 50.
Had I wanted to prejudice the affidavit and the warrant, I would have put in, I knew Kiri Jewell's story before the affidavit was drafted, and I would have put in all the details, the gory details about what he did to her. I didn't want to prejudice a magistrate, but I did want to put the context of Ms. Sparks' visit. It was put in there to show why she was there and that she was there legitimately. There was evidence of sexual abuse. She didn't drop out of the sky. Right. She had a good reason to be there.
And of course, and I think we haven't been, it's been pretty clear the warrant's okay, so I'm not going to bother you with many more questions, just reiterating the fact, defense lawyers, very capable, didn't challenge, and furthermore, we found, and I'll get to that with Mr. Owen, we actually found violations of law, you did, on the compound. But just one other quick answer. You also found some other things. I think some of those are the books that you have next to you. Would you just briefly, if you could, Mr. Johnston, explain what the, or let me ask you, and then you can corroborate. As I understand it, those books explain how to make bombs and things like that, and they were found on the compound.
Well, these books were ordered and sent to the Davidians. They, along with, in and of themselves, they might just be interesting reading, but they go with the materials they had. This one, which they had, these were introduced at trial, Congressman.
Improved landmines, it says.
Improvised landmines, their employment and destructive capabilities.
Right.
CIA field expedient methods for explosive preparation.
Okay, et cetera, et cetera. We'll submit for the record all of the names.
Anyway,
I just would like to ask, those weren't being used as paperweights, were they, when you arrived, when you saw them?
The things they had fit into the talk in the books.
Thank you. Okay, Mr. Owen, and again, I apologize. All of these witnesses have put lots of their lives into this case, and it's sort of unfair to rush through, but I have so many points I want to make. I have to. And Mr. Johnston, I think you've done an excellent job on this case, and we very much appreciate it. Mr. Owen, would it be fair to say, and don't be modest, that you're an expert on firearms?
Yes, sir. I've been recognized as an expert.
Okay. Here is my question. You were on the scene. You identified guns from the compound. Could you tell us briefly about that?
I was assigned to assist both the FBI and the Texas Rangers at the evidence collection point.
This is how many days after the...
This was the day this search began. It was several days after the fire.
Got it. Could you identify any of those weapons that you actually saw at the compound?
Yes, sir. In fact, the representative of the Texas Rangers has several of the weapons.
They happen to have them here? Good. Could we see, could one of the Rangers please show us one of the illegal weapons that were found at the compound? The actual weapon is here, and you're from the Rangers, sir. We thank you for your help.
Sergeant Jim Miller of the Rangers.
Thank you, Sergeant. Could you just hold that up? Yes. Now, Mr. Owen, do you have to go over there and examine them, or is it sufficient for you to see from here? Are those weapons that, could you name what they were? Could you hold that one up, please, sir? Stand up, please.
I need to see it a little bit closer.
Go over, please. And could the other gentleman just stand up so the committee can get some idea of... Okay, now that one's obviously charred. Can you just tell us what these were and if you found them at the compound?
This is a converted AR-15 type rifle manufactured by the
converted being made into an automatic.
It gives me every indication it's been modified due to the presence of a pivot pin hole that mounts an M16 automatic sear.
Right.
The barrel has been modified by drilling holes through the sides of it. A copper wool pad is wrapped around the barrel with an outer casing. This is very typical of sound suppressor or silencer construction.
Thank you. And the other one, just briefly, is it the just let me ask you and you can answer. Is that a weapon illegal that you found at the compound?
This is an AK-47 type rifle that has been converted to permit full automatic fire.
Making it illegal?
Yes, sir.
Thank you, Mr. Owen. And Mr. Aguilera, this is what you were afraid that you might find, I guess, when you put the warrant together.
Yes, sir.
Thank you. My final questions are for Dr. Perry, who, Dr. Perry, you interviewed the 21 children released from the compound during the standoff. Based on your team's interviews, what type of lifestyle were the children exposed to and how healthy was this? Did the children understand who their families were? I'm going to let you finish up, so I want to ask these quickly.
We worked extensively. We didn't just interview them. We basically lived with these kids for 2 months. We had a large team of experts, with much more expertise than the religious and the social apologists who have tried to make this sound like it was a benign religious community. I know of no religious sect that practices grooming children from the age of 4 and 5 to be sex objects of the leader. We basically
It almost defiles the name of calling it a religion.
Well, it actually is, I think, for many people who are practicing Christians, it's very offensive to suggest that engaging in sex with children is a legitimate part of our belief
Right.
system.
And how about discipline? What'd you find
We
about
found
that?
that the kids were inappropriately and excessively disciplined, physical discipline that was clearly abusive. We found a whole variety of other practices, which I've described in my statement and the appendices, which I would like to have entered into the record, please.
Without it,
There's the other thing that we found was, and I think that we can't really be any more, our conclusions were very independent of the very compelling story of Kiri Jewell.
Right.
We came to a very similar understanding of the belief system, the apocalyptic views, the sense that there was a willingness to engage in an abstract suicide, completely independent of any information from Kiri Jewell.
Two other questions. My
Yes.
colleague, Ms. Slaughter, in asking both Kiri and Mr. Thibodeau questions, asked two things about paddling, so
Yes.
that the bottoms were black and blue of very, very young children. I think 8 or 9 months was mentioned. Did you find that to be the case?
Kids reported that, and we found 2 of the children, and all of the children actually very openly spoke about being paddled with the helper. 2 of the children had physical lesions at the time of release after the shootout, where they had, initially they would not disclose what that was. Later on they told us that was from being paddled with the helper.
Right. And second, the instance that was mentioned about putting a child, I think it was in a garage without...
We heard that story from the children. We also heard many other instances of withholding food, of physical isolation, of a whole variety of inappropriate
Right. And you heard this directly from the children?
We heard this directly from the children.
So maybe Mr. Thibodeau didn't talk to enough people there.
I think that one thing that's very important to remember is that the men in the compound were kept and lived separately from the women and children. So Mr. Thibodeau's ability to make comments about the lives of the children, I think, is quite limited.
Well, thank you, Mr. Perry. I heard even you did a comparison of the children's heartbeats.
Yes, we did. We were, one of the things that has been commented on in these hearings, and by many people who do not understand what happens to traumatized kids, is that just because they are compliant and they behave well, that there's the assumption that they are mentally healthy. I think that there's no way to predict in this room, because everybody has been essentially compliant, which one of us is depressed, which person is mourning the loss of a loved one, and so forth. Children are no different than adults in their ability to hide their inner feelings. When we examined these children and looked at their baseline heart rates over the entire period of the 2 months that between the original shootout and the fire, we found that they were abnormally elevated. And this elevation was consistent with an internal sense of extreme distress, which was, we believe, was
And in
from a variety of
conclusion,
reasons.
just one quick yes or no.
2 minutes.
You're very generous.
I'm
I was
glad
just
you
wondering if the children could be characterized as traumatized.
Absolutely.
Thank you.
Okay. Mr. Ehrlich from Maryland for 15 minutes.
Thank you, Mr. Chairman. I want to thank everybody for appearing here today. Before I begin my questions, I'd just like to make a few points I think they're important to make. The purpose of my questions is not to choose sides, certainly. It's not to hold up anything. I'm bad on photo ops. It's certainly not my intent to put anyone on trial with respect to their careers, nor is it my intent to put anything on trial, including the NRA, including the contract with America. I'm just keeping a list today. The BATF, the militias, the assault weapons ban, gun control generally. It's not even my intent to put David Koresh on trial. I'm convinced David Koresh was a bad guy. He had sex with kids. He's a real bad guy. I'm just a freshman from Maryland, and I represent a couple 100,000 people, and a fair percentage of those people have some legitimate questions about the way this whole thing was handled. That's where I'm coming from. I know it's Washington. It's fun to spin. I'm interested in some facts, and I have some very specific questions for you all, and I really appreciate your answers today. My first question, Mr. Johnson, you've touched on this with respect to a question from Mr. Barr, and I wanted to develop it further. I believe you were asked whether or not you had stated that during planning meetings with ATF, you would not support the search warrant for the Davidian Center unless the dynamic entry was utilized. I believe you disagreed with that testimony. I believe that testimony came from the trial. Can you elaborate further, please?
Yes, I disagree with it. It wasn't testimony at trial. It was an allegation by a defense attorney. And it was something that came up in court having to do with, it was out of the presence of the jury at any rate. It's been an allegation. There have been a number of allegations against me like that. The other day someone said that I suggested they call in airstrikes on the compound and I put Attila the Hun to shame. And that's just as untrue, of course. But at any rate, I don't know about Attila the Hun. At any rate, I was not involved in planning meetings with ATF as to the raid, only into the preparation of the search warrant. I did not tell them what kind of raid to do. I didn't know exactly what kind of raid they were going to do. I did know it involved cattle trailers, and I did know that it was some kind of a ruse they were going to try to pull in under the disguise of cattle trailers. But I didn't know all the details, and that wasn't my function.
And thank you for that. I asked a very specific question and got a very specific answer, and I appreciate it very much. Secondly, with respect to the whole military involvement, and Mr. Schumer developed this line of questioning, you would all agree, I believe, that aircraft from the National Guard, flashbangs, use of flashbangs, the MP5 rifles, etc., they're not specific to military-type missions. Would that be generally agreed upon? Anybody want to answer that?
Yes, sir, that's correct. They're not specific to military application.
Now, sir, you would agree, however, that the use of Bradley fighting vehicles would be specific to a military mission, correct?
My knowledge of the Bradley, it is a military vehicle. It's a combat vehicle.
And, sir, at some point in time, ATF made a request that was subsequently withdrawn with respect to, I believe, either 7 or 10, I've read different versions of it, a request for 7 or 10 Bradley fighting vehicles with respect to a proposed raid. Is that correct?
I have absolutely no knowledge of that.
Does anyone on the panel have any knowledge of that?
I think there was an original request in our early planning for what we were going to do. We were talking about doing a siege, and at that time there was a request that went forward.
Sir, let me just follow up. Mr. Serban?
Yes.
It's my understanding that there's no formal standard in law by which the military defines a drug nexus. It's my understanding that pursuant to law and regulations promulgated by Department of Defense or the Army, that there needs to be a drug nexus allegation prior to military involvement. Is that correct?
It's my understanding that and you'll have to ask the military, which we'll be on later, that at the time that there was a nexus request. Now, they can supply certain things. If there's a nexus, then it depends on who would pay for it.
Right, because if you get the military, if you prove the nexus, you get the military and it's free, correct? The military involvement is free.
That is correct.
Okay. Now, I guess with respect to Mr. Schumer's line of questioning, I'm confused because I understood the answers he received from the subsequent panel about, although he did not get into the Bradley fighting vehicles, the bottom line to his line of questioning was no military involvement, period. Yet I read in today's Washington Post that Ron Noble, Assistant Secretary of the Treasury, made this statement: the kind of support that the ATF received from the military in this case was the kind of support you'd want them to receive. Lives were saved because of the assistance they received from the military. Now, I realize Mr. Noble's not here, but does anyone possibly know what assistance he's referring to?
Yes, sir. I believe the assistance he's referring to there is probably the emergency medical training that was provided by Special Forces to ATF agents, to ATF medics in advance of the raid. We did document in the report acts of sheer heroism by the medics at ATF at the raid. They were trained by Army medics in battlefield-like life-saving techniques, and lives were saved as a result of that.
Sir, your answer is that quote, to your understanding, I realize he's not here, you're only suggesting a possible answer, only referred to the military training, I'm sorry, the medical training and not training with respect to training for the actual raid on the compound?
I obviously can't answer as to what Mr. Noble had in mind when he made that quote. The life-saving assistance provided by the military that I'm familiar with is the medical, emergency medical assistance that was provided to ATF medics.
Thank you. Let me switch my line of inquiry here. It appears from everything that we've been informed concerning this raid that ATF at some point lost the element of secrecy. Koresh himself visited this is Mr. Tiburo's testimony from the earlier panel, visited his next-door neighbors and stated that he believed that quote-unquote college students were too old and had new cars and were probably FBI agents. Koresh complained to the local sheriff. The UPS delivery man was an undercover police officer. He did not appreciate being investigated. The Davidians visited their new neighbors. They were not treated as new neighbors would be expected to have been treated, etc. My question really is, was there any thought prior to conducting this raid that the element of secrecy had been lost? The second part of that question is, if the answer is yes, why was the warrant attempted to be served according to the procedure which occurred? I'll let anyone answer that question.
Sir, I'd like to have the opportunity to answer that question, and I certainly think it's appropriate if a representative from ATF does as well. Those were really the central questions that we addressed in the Treasury Review 2 years ago, and a good portion of our report was devoted to examining those questions and offering answers.
Can I just, I will come back to you. Okay. I will come back to you, and I understand your role here. I would like the ATF agents present to answer the question, and then I'll get back to you.
With respect to the element of surprise.
Yes, sir.
On February the 1st, a decision was made, and I'm sad to say I was a part of that decision, to entrust the news media at the Waco Tribune-Herald with certain information about our investigation. And that was because they continued to make contact with folks in the U.S. Attorney's Office and other law enforcement agencies with the threat to break a series of articles about the Branch Davidians that they had been working on for a long period of time. We met with Barbara Elmore, who I believe was a managing editor at that time. When I say we, Mr. Sarabin and I. And we asked if we could speak with her off the record, and she agreed. We explained to her that we had a very sensitive investigation going on, and that an untimely breaking of the news about the Branch Davidians would certainly hamper the success of any search warrant that might come about, and could and probably would put the safety, if not the lives, of both federal agents and those occupants of the compound into jeopardy. Ms. Elmore said in response that she wasn't going to make any promises, that she would talk to her supervisors at the paper and would let us know at a later time. Not to belabor this or take it too far, but on the Wednesday prior to the warrant being executed, in the afternoon at about 3 o'clock, Mr. Hanowski met with members of the Waco news media, newspaper specifically, at their offices, and as he began his statement of appreciation for their cooperation, he was immediately interrupted by one of the supervisors there and was told that he wanted, the newsman said, "I want it clearly understood that this newspaper is not cooperating with law enforcement in any shape or form. Our search was planned for March the 1st. We were notified after that meeting with Mr. Hanowski and the news media that they intended to break their lead article on February the 28th, Sunday. We set in motion activities to back the date of the warrant execution up to Sunday, hoping that we could at least execute the warrant on the same day that the lead article came out. And then we were notified, after having made those arrangements, that the newspaper decided they would break their lead article on Saturday, which they did. When the raid team arrived at the compound, there was news media personnel all over the area already, one of whom had been contacted by David Jones, and he, the newsman, tells David Jones, "You better get out of here. ATF's fixing to raise this place." Now, when we talk about element of surprise, is the element of surprise lost when the first article comes out? Or is the element of surprise lost and we were unaware that the news person had told David Jones that until afterwards?
Hey, sir, if I can cut you off for a second. I realize I'm running short of time. Is it your testimony that the press awaited you all when you arrived at the compound to conduct the raid?
Yes, sir.
Did that give you any hint that the element of secrecy may have been compromised?
We did not recognize them as the press as we were coming, as the raid team was coming in. They didn't recognize them as the press at the time.
Okay, sir, let me ask you this question. Besides the formal avenue of the press, did any of the other testimony produced here today or any other facts come to your attention that would have raised a question in your mind as to whether the element of secrecy had been compromised at any point prior to the raid?
When we talk about the element of secrecy as opposed to the element of surprise, the element of secrecy about our raid, we didn't feel was compromised at that point.
Okay, so your testimony is that you all believed, and I'm just trying to get your viewpoint here.
Yes, sir.
Prior to that raid, 10 seconds prior to the beginning of that raid, you did not feel as though the element of secrecy or surprise had been compromised. Is that correct?
No, that's not correct, sir. 10 seconds prior to the raid, I feel like the secrecy was lost at that point.
Okay.
Your time has expired.
Thank you. I'll have an opportunity to follow. Thank you, Mr. Chairman.
We're going to have to recess. I believe there are 2 votes. You'll be patient. We appreciate that. And we'll be back 5 minutes after the second vote.
Absolutely.
We'll continue with the Waco investigation in a moment. But first, some program information.
Bruce is next.
Sunday night on Book Notes. In 1979, Newt Gingrich was a freshman on Capitol Hill. This weekend, the House Speaker talks about the people in his political career.
Joe Gaylord is a remarkable student of American politics who was the Iowa State Republican Party Executive Director. Then he came to the Republican National Committee and was the National Director for state legislatures in 1980 when we picked up 700 seats. Then he went to the Congressional Campaign Committee and ultimately became the director of it, and was in charge of designing the 84, 86, and 88 campaigns, and then became a consultant. He is one of my closest personal friends, and he is a man whose judgment I regard as extraordinarily good overall. I mean, just has a remarkable ability to know what not to do and to know where the landmines are in American politics. In June of last year, he wrote a paper that described 231 seats. 224 by winning and 7 by switching. We ended up at 230 by winning and now 2 by switching, so we're 1 ahead of his goal. We then executed that paper, and in September, and I think it's September 17th or 18th, it's in the book, we got on an airplane and we were going to have a planning meeting, and I said, are we planning for speaker or for minority leader? And he just said very bluntly, you better be planning for Speaker because that's what you're going to be.
Speaker of the House Newt Gingrich and his book, To Renew America, on the next Book Notes, Sunday night at 8 Eastern and Pacific Time.
We now continue with the Waco investigation, the first day of hearings before a House Joint Subcommittee. Chairing the hearing, Republican Bill Zeliff of New Hampshire and Republican Bill McCollum of Florida.
Subcommittees will come to order. The gentleman from Oklahoma, Mr. Brewster, has 15 minutes.
Thank you, Mr. Chairman. As one who happens to believe that ATF and FBI do an awful lot right, probably 90–95% of your cases are never heard of by the media or by the average American. My main interest in this is trying to figure out what went wrong in the deal. I think that some of my colleagues here are attempting to play a